Check 1, 2. Check 3, 4. Mr. Lowry, can you hear me?
Yeah, I'm not as familiar with WebEx as I am Teams.
Okay. Looks like I'm on. All right, Wendy, thank you.
You bet. Bye.
Bye.
Nash Long?
Yes. Hi, Nash Long here.
Hi. Yeah, just saying we can hear you and see you, and just so you know, your mic is on and your camera is on right now. I don't know if you want to mute it until we get closer, but we
I
can.
will, but thank you for letting me know. Just trying to get all the
Sure.
kinks worked out here. Appreciate it.
Sure. Jim Lowry, are you there?
I am. Can you hear me?
I can hear you. Yes. Just letting you know that your microphone is on. I don't know if you intend it to be on, but you may want to mute it until we get closer to the event.
Yep, thank you.
Thank you.
Right. Okay. Let's see.
Judge, I had trouble before with hearing people. I don't know if I have that issue now or not.
I can hear you just fine, Mr. Williams. Can you hear me?
I'll
You
try
both-
connecting by phone to get the audio.
You're both coming through fine. I've been chatting with people throughout to make sure their mics are muted. We can
I
hear you
don't
both
think,
fine.
I don't think Mr. Williams can hear us. We can hear him, and I think you can hear me. I don't think Mr. Williams can hear us. This happened during a discovery conference as well.
I have called through now.
Nathan, you are feeding back at that point. You may have a couple things open there.
I'm aware.
Nathan, are you also the call-in user?
Yes, I am.
Okay, there, your feedback seems to be gone.
Yeah, I was aware it was because of the computer and the phone. I'm just using the phone currently.
Okay, yeah, that sounds, no feedback anyway.
Okay, it is now 9 o'clock. Are we still waiting on anyone to join?
This is the court reporter. I'm here.
And what is your name, please?
Joanne Richardson.
Ms. Richardson, thank you very much. We're delighted to have you today.
Oh, thank you. I'm just trying really quick. It took me a while to get on because she sent me the wrong link. So I'm trying to pull up the exhibits that you all sent really quickly.
Now, I will tell you that it is customarily the practice here at the commission for us to retain and mark the exhibits.
Oh, yeah. They were just giving it to me for my reference, I think.
Okay, all right, thank you.
Yeah.
Be sure we were.
I'm gonna see if this one will. I can find it. Just 1 minute. I'm sorry.
That's okay. Ms. Richardson, would you let me know when you're ready to go on the record?
I will. Just give me 1 second.
Judge, this is Jim Lowry. I did send the court reporter, Mr. Homestead's pre-filed testimony because we're going to be bringing a DVD with all the testimonies Monday, but obviously we aren't there physically. So I sent those to the court reporter in advance so she would have those.
Okay, thank you, Mr. Lowry. And we're going to get started a couple minutes late. We'll get started very shortly.
Okay, just a second. I'm almost there. All right. There. All right. Okay. There. Okay. All right, sir, I'm ready. And I don't really, it's Mr. Lowry. You're, are you the commissioner, Mr. Clark, or I'm not really sure. I haven't done one of these. I've done depositions, but I haven't done this, so.
I'm the regulatory law judge presiding over this proceeding.
Okay.
There are going to be commissioners that are in attendance today, including the chair of the commission, Chair Han, who is currently on. There are attorneys such as Mr. Lowry. I'm going to go through and make everybody do their introductions.
Oh, okay.
If at any time you don't catch something or somebody's speaking too fast or you want me to go over something again, please let me know and I will be happy to do so. Okay.
We are on then. Thank you.
Okay. So you're ready to go on the record?
Yes.
All right, let's go on the record. Good morning. Today is April 12th, 2024, and the current time is 9:03 a.m. This proceeding is being held electronically via WebEx. As the commission is taking one witness out of order today due to the witness being unavailable during the rest of the hearing, which is April 15th through the 19th. Now, the commission has set aside this time today for an evidentiary hearing in the matter of the petition of Union Electric Company doing business as Ameren, Missouri, for a financing order authorizing the issue of securitized utility tariff bonds for energy transition costs related to the Rush Island Energy Center. And that is file number EF-2024-0021. My name is John Clark. I am the regulatory law judge overseeing this proceeding today. Chair Han, would you like to make any opening remarks before I ask for the introduction of the parties?
Good morning, and thank you all for being here. I really appreciate everyone's attendance this morning. I know this is going to be a series of days for us, and I look forward to learning more in the case. Thank you, Judge. Appreciate it.
Thank you, Commissioner Hunt. At this time, I'm going to ask counsel for the parties to enter their appearance for the record, starting with Union Electric, doing business as Ameren, Missouri, whom I will refer to from this point on as Ameren or Ameren, Missouri.
Good morning, Judge. My name is Jim Lowry. I represent Ameren, Missouri, along with co-counsel Nash Long. I'll let him make his own appearance.
I'm having difficulty hearing Mr. Lowry. He sounds like he's in a tunnel or something.
Okay. Mr. Lowry, could you enter your appearance again one more time? And I'm not sure what,
Yes, I'll try to speak a little more loudly. This is Jim Lowry, 9020 South Berry Road, Columbia, Missouri, 65201, appearing on behalf of Ameren, Missouri.
Good morning, everyone. My name is Nash Long. I'm also here on behalf of Ameren, Missouri today.
and what's your last name again?
Long, L-O-N-G.
Okay, thank you, Mr. Long. On behalf of the staff of the commission,
On behalf of staff, Nicole Mers, 200 Madison Street, PO Box 360, Jefferson City, Missouri, 65102.
thank you, Ms. Mearns. On behalf of the Office of the Public Counsel,
Nathan Williams, Chief Deputy Public Counsel, appearing on behalf of the Office of the Public Counsel and the public. Our address is P.O. Box 2230, Jefferson City, Missouri, 65102.
and Mr. Williams, any objections to me referring to the Office of the Public Counsel as either Public Counsel or OPC?
No.
Thank you. On behalf of Midwest Energy Consumers Group,
Good morning, Your Honor. Tim Opitz on behalf of Midwest Energy Consumers Group, or MECG.
thank you, Mr. Opitz. On behalf of Missouri Industrial Energy Consumers, anyone here from Missouri Industrial Energy Consumers or MIEC? Okay, well, they may show up later. On behalf of Renew Missouri,
Yes, good morning, Judge. This is Andrew Linares, entering appearance for Renew Missouri, address 3115 South Grand Boulevard, Suite 600,
Thank
St.
you.
Louis, Missouri. Sorry,
go ahead, Mr. Linares, I was interrupting you.
St. Louis, Missouri, 63118. Thank you.
I apologize for the interruption. Thank you, Mr. Linares. On the Natural Resources Defense Council will not be here today. They filed a motion to be excused from this hearing, and that motion was granted. They indicated that they had neither witnesses to present nor cross-examination that they wanted to do. On behalf of AARP.
Good morning, Your Honor. John B. Kaufman. I'm appearing today on behalf of AARP as well as on behalf of the Consumers Council of Missouri.
Okay, thank you. Thank you, Mr. Kaufman. And on behalf, well, I'm sorry, I will say finally, we have the Sierra Club. And Sierra Club also filed a motion to be excused, similarly stating that they had neither cross-examination nor witness testimony that they wished to present. And so that request to be excused was granted. Have I missed any parties? Okay. Are there any preliminary matters that I need to take up at this time?
This is Nathan Williams for Public Counsel.
Go ahead, Mr. Williams.
We have pending a couple of motions for leave to correct some schedules. I don't know if you want to take those up now or later.
It is my intention to grant those motions to correct your schedule. So I don't know if that's sufficient. I will grant that motion.
Thank you. Well, there are two, actually, one for Mr. Riley and then some schedules for Mr. Murray.
Well, let me ask, are there any objections to granting the correction of those schedules? I hear no objections. Both of those motions will be granted.
Thank you.
Are there any other preliminary matters at this time?
Judge, this is Commissioner Holzman. I've joined.
Thank you, Commissioner Holzman.
Judge, this is Jim Lowry. Mr. Long will be delivering a mini opening statement on this issue this morning, and he does have a PowerPoint presentation, and I was wondering if I could send that to you and you can provide it to the commissioners, and I'll also send it to the parties if that's okay. I can do that now by email.
Okay, hold on just a second. we're going to go off the record for just a second so that I can speak to Mr. Layman's and see if we need to make any accommodations for that. I was unaware that we were going to have any PowerPoints this morning. Mr. Layman's, is there that I should have made earlier. So if you are not speaking, just so it is easier for everyone else so that they don't pick up background noise like the microphone picked up my child yesterday, then that would be good. At this time, I'm going to go ahead and introduce the commissioners. As I said before, Chair Hahn made some brief introductory remarks, and Commissioner Holzman
Are we
has.
back on the record? I'm sorry, you went off the record. Are we back on or?
Oh, I'm sorry. You are absolutely right. Thank you, Ms. Richardson. Let's go back on the record.
Okay, thank you.
Okay, I'm going to go ahead. Chair Hahn has made some opening remarks, but I'm going to go ahead and introduce the rest of the commission now. Now, the commission is composed of 5 commissioners, and with the chair being Chair Kayla Hahn. And the other commissioners, right now we have Commissioner Scott Roop. Commissioner Roop, are you on? Commissioner Roop. Did I hear somebody? Commissioner Roop may be joining us later. I've also got Commissioner Maida Coleman. Commissioner Coleman, are you present at this time?
I am. Good morning.
Good morning. Thank you, Commissioner Coleman. Commissioner Jason Holzman has already indicated he's on. Good morning, Commissioner Holzman. And we also have, thank you, and Commissioner Glenn Kolkmeyer. Are you on at this time? And Commissioner Kolkmeyer will most likely join us in a little bit. With that, I'm going to move on. Confidential information. There's a lot of confidential information in this case, and I am not off the top of my head going to remember what information is confidential. So I am relying on the parties to let me know if we need to go in camera. If it occurs to me that we may need to go in camera, I'll ask questions and do so. But if you hear something coming up that sounds like it's going to be confidential, I would appreciate if somebody would let me know so that we don't inadvertently put something out there that is confidential in nature and not intended for public consumption. At the same time, there's some numbers in here that I'm not sure why are confidential. And so we may also have a discussion in regards to that. Now, I received an email, as I believe you all did, from Mr. Lowry asking if the parties could do a mini opening statement to set the stage for this issue, since we are taking an issue and we're taking a witness out of order, not an entire issue, but this witness, I believe, just pertains to issue 3, which is the prudence of the retirement. And I believe just to section A of that. Is that correct, Mr. Lowry?
That is correct, Judge, yes.
And should I direct my questions on this to Mr. Nash?
Yeah, Mr. Long is actually handling this issue.
I'm sorry, Mr. Long.
Yeah. So, yes, thank you.
Thank you. And as far as the order for many opening statements, I'm going to go with the order that was put forth for opening statements by the parties, unless I hear something else, and that would be Ameren, Missouri, followed by the staff of the commission, MIEC, who does not have an attorney here yet, AARP, MECG, Renew, and Public Counsel. So with that, are there any, I know I heard from a few people, are there any other preliminary matters I need to take up beyond what we've covered already? All right, let's proceed. With Ameren, Missouri, Mr. Long, you can start your mini opening statement for this issue.
Thank you, Judge. Let me share my screen and we will get started. All right, can the parties and the commissioners and the judge see the screen just to check?
I cannot yet.
Nor can I.
Then I will fix that. And how about now?
I can see it now. Thank you very much.
Thank you. Sorry for that. Good morning, everyone. My name is Nash Long here on behalf of Ameren, Missouri. We will be presenting a short 10-minute mini opening on issue 3A, which is the prudence of the company's decisions regarding permitting for the Rush Island Energy Center in the years leading up to 2007 and 2010. I'll be walking through this PowerPoint, presenting an overview of the issues and an introduction of the witnesses. And the first issue that we'd like to introduce is the reasonableness of the company's permitting decisions for new source review. And that relies upon the following evidence which will be presented at trial. First, the company, in making these decisions, relied upon Missouri law and the opinions of Missouri regulators, that is the Missouri Department of Natural Resources. They also relied upon statements from the EPA program office in charge of new source review regulations. They relied upon the advice of national new source review experts, and they made decisions that were consistent with the rest of the utility industry, which did similar work without seeking permits over the course of decades. And finally, their decisions at the company on not seeking permits were consistent with most court decisions that were being entered at that time. What is new source review? New source review has been part of the Clean Air Act for nearly 50 years now. Under this program in the Clean Air Act, a new source of emissions will require a permit before it can be constructed. It does not apply to existing sources unless that existing source undergoes a modification. The Clean Air Act defines modification as a change that would cause emissions to increase, but the Act did not specify how to measure emissions. Missouri law, which has been approved by EPA as implementing the Clean Air Act, defined modification as an increase in potential emissions. That is the maximum amount of emissions that could be emitted under the design of the unit. Federal regulations, in addition, those found at 40 Code of Federal Regulation 5221, required a significant increase in actual annual emissions for a major modification. And this is how it works under the Missouri SIP at the relevant time. A series of questions and answers which tell one whether permitting is required under the federally approved State Implementation Plan, SIP or SIP for short. First question, does the project cause any increase in potential emissions? That is the definition of modification. If no, then the permitting rule under the approved SIP is not applicable. A permit is not required, no permit of any type. On the other hand, if the project would cause an increase in potential emissions, that is, be a modification, the next question is, what is the size of this potential emissions increase? And depending upon the answer to that question, the size of the increase, different types of permits might apply. If the potential emissions increase is under 40 tons per year, the Missouri SIP under the construction permitting rule specifies what is called a de minimis permit to be obtained. If, on the other hand, the size of the potential emissions increase is 40 tons per year or greater, then the Missouri SIP invokes the Federal Prevention of Significant Deterioration or New Source Review rules. And those rules require that a project must also cause a significant increase in actual emissions. And that is an element for the definition of major modification. If the project would not cause actual emissions to increase significantly, then no PSD or new source review permit is required. If, on the other hand, the project would cause actual emissions to increase by that significant amount, that is over 40 tons per year, then the new source review permit, the PSD permit, is required. Many times you will hear throughout the course of the presentation of evidence on this issue, folks refer to PSD, Prevention of Significant Deterioration, and new source review interchangeably. They are functionally the equivalent. It depends upon whether the area at issue is in attainment of the standards for ambient air or not. But the fundamental program has been titled and referred to as new source review over the years. And so I and many witnesses will refer to PSD as part of and included within new source review. But the first question and the fundamental question under the Missouri SIP, before you get to any of those questions, is whether the project causes any increase in potential emissions. And if no, under the established interpretation and application of the Missouri law that had been approved by EPA as implementing the Clean Air Act, no permit is required. You will hear from Ameren, Missouri witnesses about the process they used at the relevant time frame, that is 2005 to 2010, on making the determinations of whether projects required permits under the Missouri SIP. At the company, at the time, the Environmental Services Department, in particular its air quality group, conducted the pre-project reviews necessary for compliance for all existing units. They did so both for Ameren, Missouri and the state of Missouri, as well as for the sister utilities located in Illinois. If the department found that a project would trigger new source review, then the department would initiate permitting. One example of that, which you will hear about, is the Duck Creek facility in Illinois, where a project was going to increase the potential emissions. That project, because it would increase potential emissions, underwent the review. The company found it would require a permit. The company sought the new source review permit and obtained it. But here, if projects were found not to trigger new source review, then the department would give the go-ahead and the project would commence. There was no documentation required of those decisions at the time under the existing rules, nor was it needed because the rules simply required the company to use its basic engineering judgment in making the determination of whether emissions would increase. No requirement existed at the time to document it, and as a matter of basic engineering, there was no calculation that was required to make this judgment. Specifically with respect to the decisions at issue, these were the decisions leading up to the Unit 1 work in 2007 and the Unit 2 work in 2010. New source review is a pre-project permitting program. The decisions are to be made by the source, the company, before one actually begins work. And it was in that time frame, in the years leading up to 2007 and in the years leading up to 2010, that the company actually made the decision these projects would not trigger the new source review requirements under the SIP. It did so through the Environmental Services Department, which you will hear followed its normal process for making those determinations. That department also applied the same criteria that had been applied in Missouri for years. The department concluded that for this specific work, for these specific units, no permit was required under the Missouri State Implementation Plan for the reasons that we will talk about. First, There was no increase in potential emissions for any of the work involved. Therefore, it did not meet the definition of modification. And under the established interpretation of the Missouri Construction Permitting Rule, adopted into the state implementation plan and approved by EPA, no permits were required. The second reason that the Environmental Services Department found new source review would not apply is they did not expect projects to cause annual emissions to go up, and therefore it would not meet the definition of a major modification either. The third reason that the company, through the Environmental Services Department, employed was because the work involved was just the routine replacement of parts and components on existing units, so it did not meet the requirement or the definition of a change. The company could have stopped with reason number one, no potential emissions, therefore not a modification, relying only on the SIP, that is the Missouri State Implementation Plan. However, it also evaluated and considered the other two reasons and found them to confirm and strengthen the company's conclusions that no permit was required. Is there a question? I'm sorry.
I don't believe so. I believe that was just some background noise. Again, I'm going to remind you, if you're not currently speaking, please mute your microphone. If you're attending by phone, if you can mute your phone, I would appreciate it. If you'll go ahead, Mr. Long.
Thank you, Judge. You will also hear from the witnesses how the permitting decisions were made and what they were based upon. They were based upon the knowledge and experience of the professional staff in the Environmental Services Department, relying upon the text of the Missouri State Implementation Plan, which I've already outlined and walked through. They relied upon guidance given by the state through its Department of Natural Resources and by EPA through its program office. They relied upon the shared knowledge and experience of the utility industry, not just within Missouri, but nationwide. And they also relied upon the input of lawyers with recognized experience in new source review. The conclusion from all of the evidence presented will be that the permitting decisions were reasonable. The company held the same positions as the Missouri Department of Natural Resources at the time. The company held the same positions as the EPA program office at the time. The company made the same decisions as the rest of the industry on similar projects, all concluding that they did not require permits at the time. And the company made the same decisions as most courts at the time, and even since. All of these facts, which will be presented through the witnesses by Ameren, Missouri, we submit will support the reasonableness of the decisions the company made at the time in that period, 2005 to 2010, that no permits were required. There's been much talk about the subsequent case decided years later, 7 to 10 years later after these decisions were made, and whether that somehow makes the reasonable decisions the company reached in its compliance process somehow unreasonable. And that is not the case. The Clean Air Act, as you will hear, has a strict liability standard. It does not turn on negligence, reasonableness, exercise of due care, or prudence. In addition, you will hear from the witnesses pointing out how the district court in its later decisions relied upon facts, data, and case law that was developed after the fact. In other words, it was not conducting a prudence inquiry, could not have made a prudence inquiry because of the incorporation of those decisions, facts, case law, etc., which came after the fact. Certainly, the district court disagreed with Ameren, Missouri on the law, but it did not never found that Ameren, Missouri had an unreasonable understanding of what the law was. And finally, Ameren, Missouri's decisions were well supported and reasonable based upon what was known or available at the time. That will be presented through the following witnesses. First, Mr. Martin Burke. He was an electrical engineer by training. He's now the president of Ameren, Missouri. But at the relevant time, 05 to 2010, he was the vice president of power operations. And he will explain the company's operations, its desire to maintain system reliability, its obligation to maintain unit availability, the practices of component replacements designed to do such, and how that was all consonant with routine industry practice. He'll describe the compliance process that existed at the time at Ameren, Missouri, and the role of the Environmental Services Department. And he'll touch on the decisions concerning Rush Island that were made by the Environmental Services Department and supported by the rest of the company. The next witness is Mr. Stephen Whitworth, who retired fairly recently. At the relevant time, 2005 to 2010, he was the head of the Air Quality Group and then became the manager director of the Environmental Services Department in which the Air Quality Group sits. He will explain the process that was applied by the company in order to ensure compliance, the criteria that it used in general and with respect to Rush Island. He'll explain where those criteria came from. In other words, the due diligence performed by the company in developing its understanding of the law. He'll describe in detail the decisions the department made on Rush Island and why it concluded that under the established criteria, no permits of any kind, including new source review permits, would have been required. And he'll also describe how these decisions were subsequently confirmed by the actions and statements of the Missouri Department of Natural Resources. Next, Mr. Homestead, who will be taking out of order and you hear from today. He is ranked as one of the country's leading Clean Air Act lawyers. Significantly, he was the former assistant administrator for EPA for the Air and Radiation Office, which is the office that had responsibility for the new source review program at EPA. Since he left EPA in 2005, he's been working on these and other issues as head of an environmental group at his law firm. He's been working with utilities on new source review throughout this relevant time frame. And his topics will include explaining how the Clean Air Act works, with the states in the lead, subject to EPA oversight. He'll explain the implementation and application of the law through the state implementation plans approved by EPA. He will explain the application by EPA at the relevant period of time, 2005 to 2010, and how utilities complied with the law then and now. And based on this, he will offer the opinion that the company made reasonable decisions based upon the known and knowable facts available at the time. The final witness that you'll hear from the company on this issue is Mr. Carl Moore, who is also an expert in environmental law, recently retired from EPA, where he too served in the Air Program Office, the same office as Mr. Homestead in an earlier time frame, that same office that had responsibility for new source review at the EPA level. But at the relevant time, 2005 to 2010, he worked at Southern Company, a large electric utility, where he focused on new source review and provided advice and counsel on new source review to his client, Southern Company, throughout this relevant time frame. He will explain also the application of the Clean Air Act through the state implementation plan, the role of the state implementation plan and the state regulator, new source review, industry knowledge of new source review, and the case law that was developing on new source review at the time, and concludes based on all of those facts that the company made reasonable decisions based on what was known and knowable at the time. Let me also talk about the other witnesses who touch on these issues. The first, the staff witness, Claire Eubanks, who is an environmental engineer. Her testimony does not contend that the company was imprudent. The issue she raises is lack of a documentation. However, we point out through our witnesses that the company followed its standard practice did not require documentation of these decisions at the time. It did not require anything more than the simple engineering judgment that if you're not changing the design of the facility in its maximum achievable design rate, you're not going to change the potential emissions. You'll hear how nobody disputes that simple engineering judgment can be reached without doing documentation or calculations. And nothing more was required under the law that existed at the time. The other staff witness is an accountant, Mr. Keith Majors. He does say that the company was imprudent, but he rests that opinion solely on 3 court opinions, 2 by the district court, 1 by the 8th Circuit. The problem, which Mr. Majors acknowledges, is that these courts were not applying the test for prudence. The courts looked to post-project data and incorporated analyses that were developed after the project and relied upon case law that was developed after the project. None of these opinions can possibly represent a prudence determination because each incorporated and relied upon those items which are hindsight. Now, yes, the district court did write in that remedy opinion in 2019 that it had found in the earlier opinion in 2017 that the decisions made not to seek permits were not reasonable. But if you actually go back to the liability decision and read that, which you should, you'll conclude that that is not what the liability opinion actually says. What that liability opinion actually says is that the emissions case presented by Ameren, Missouri at trial did not follow the requirements of the new source review rules as the district court had laid them out in 2016. The district court there says that the emissions analysis that Ameren, Missouri provided to the court did not follow the law as the district court found in its 2016 determination, and therefore were not reasonable emission analyses under the law. That's what the opinion says. Nowhere does the opinion say that Ameren, Missouri failed to consider permitting requirements. Nowhere does an opinion say that Ameren, Missouri acted in bad faith or tried to skirt its obligations under the law. What it actually says is that the company acted based upon a misunderstanding of the law. But it nowhere says, either in the 2017, 2019, or even in the 2021 opinion, that Ameren had some unreasonable understanding of the law. The final witness you'll hear from is from the Office of Public Counsel, Mr. Seaver. He has not testified on prudence before. He does not rely on any of the district court opinions. Instead, he relies on one case from 1988 regarding WEPCO. I'm using the acronym WEPCO for Wisconsin Electric Power Company. That one case relied upon by Mr. Seaver is an instance where potential emissions were increasing and therefore permitting was required. The problem that Mr. Seaver has is that he did not know the particulars of that 1988 determination and that his deposition was forced to admit it was reasonably distinguishable from Rush Island. The other problem Mr. Seaver has is that the WEPCO case actually supported Ameren, Missouri's permitting decisions because of what EPA said about it in the years between 1988 and the Rush Island projects. And courts across the country, including this Alabama Power Court from 2008, have rejected Mr. Seaver's attempt to use this one isolated WEPCO decision as somehow meaning all projects required permitting. In fact, that court in 2008 said the same approach that Mr. Seaver is using in his testimony here was simply superficial and insufficient. In summary, the company made reasonable permitting decisions. This is illustrated by the fact that the state, through the Department of Natural Resources, held the same position. EPA's program office held the same position. The rest of industry made the same decisions on very similar projects. Most courts across the country were making the same decisions as the company made here. None of these facts are disputed or will be disputed, and hindsight and second guessing cannot overcome this evidence. Therefore, the conclusion at the end of the day will be, we submit that the company made reasonable permitting decisions. Thank you.
Thank you, Mr. Long. Are there any commission questions for Ameren's attorney? I hear none at this time. Mr. Long, Mr. Lowry, I have a few questions for you that I'd like to go over. You had indicated, Mr. Long, that you lumped the new source review and the PSD permitting together. Would you explain to me, because I didn't really understand that, can you explain to me why you're lumping those two together?
Judge, excuse me, could he unshare his screen? Could he stop sharing his screen and we can see you guys on camera?
Thank you, Mr. Lemon.
Thank you.
Yes, let me attempt to do that. 1 second. I'm not very technical.
It should just say stop sharing.
I don't think it's on your PowerPoint screen. I believe that the thing you would be looking for would be on your WebEx.
I'm trying to expand that, but I'm not able to do
It
that.
looks like it says share underneath where you X out of it. Perhaps if you hit that, it might say.
I'm sorry. How's that?
Wonderful. Thank you.
Thank you very much. Okay, back to my question. Why are you lumping the new source review and the PSD permitting together?
It, judges, is a common verbal shorthand. There are technically two types of new source review that will apply depending upon whether the area, the geographic area, is in compliance with the National Ambient Air Quality Standards. One of those types of new source review is the non-attainment new source review, sometimes referred to by the acronym NSR. And what that means is new source review for the non-attainment areas. That is, where the air is dirtier than that which would be allowed by National Ambient Air Quality Standards set by EPA. And there are a set of new source review regulations that apply to those areas, the non-attainment new source review regulations. Now, on the other hand, what about areas that are in attainment of the ambient air quality standards? Those attainment areas, the new source review program is called Prevention of Significant Deterioration. And as the acronym or the title implies, you don't want the overall quality of the air, the ambient standards to degrade into non-attainment. And so that type of new source review applies to the area where the geographic area where the ambient standards are being met. The applicability, whether something is a project that requires permitting under either of those two programs, it's the same. And so it's generally referred to together under the heading of new source review. And this is explained in the direct testimony of Mr. Homestead that he has pre-filed in this case. It's generally how practitioners in the area refer to program, the new source review program, as a whole, rather than speaking individually about attainment areas or non-attainment areas. I hope that helps.
It does. Thank you for clarifying that for me. One of your early slides said that that this was a common practice across the utility industry and indicated that other utilities did similar work without seeking permits. Is Mr. Homestead going to be able to elaborate on what utilities with particularity?
Yes, he can talk about utilities that he has experience with that did similar work. He can talk about the utilities that he is aware of without necessarily working directly with them that did similar work. And you can also ask that question too of Mr. Moore. And you could also feel free to ask that question of Mr. Burke and Mr. Whitworth at the appropriate time. I think all of the witnesses could provide you information on that, and Mr. Homestead would be prepared to start that process today.
Thank you very much. Now, this issue, just to recap the issue real quick, is it reasonable and prudent for Ameren, Missouri to abandon or retire Rush Island September 1st through October 15th of 2024? And then sub A of that, which we're addressing today, at least in regards to Mr. Homestead, is did Ameren, Missouri make reasonable and prudent decisions respecting whether to obtain new source review NSR permits prior to either or both of the 2007 and 2010 Rush Island planned outage projects and afterwards, including its conduct of NSR litigation? If any of its decisions in this regard were unreasonable and imprudent, did such imprudent decisions harm customers, and if so, in what amount? That's interesting to me because I'm kind of wondering why exactly we're talking about the new source review. And so what I want to ask you is, what decisions do you believe that the commission needs to make in this case regarding reasonableness and prudence?
The first decision is whether the retirement decision is reasonable and prudent. But questions have also been raised about the factual predicate, the underpinning of that retirement decision, which does get back to the permitting decisions made many, many years ago. And I believe at least one party has raised the issue of whether those decisions were prudent. So we are here to present the evidence that we think would show that the company made reasonable and prudent decisions at the time. And there would also be a witness, not Mr. Homestead, but later to present the issue of how even if the company had obtained permits at the time and applied scrubbers, that would have put the consumers in a worse position. So we're prepared to address all of these issues and answer all of those questions from the commission and yourself and from any party in the case, should they desire.
Okay, and I appreciate that answer, and I appreciate that you're here to answer all those questions. What I'm asking is, what reasonable and prudence decision does Ameren believe the commission needs to make in this case? Not what are the issues that the parties have put forth. What decisions concerning reasonableness and prudence does Ameren believe the commission needs to make in this case?
Judge
Your Honor.
Lowry, maybe I can help answer.
Hold on
that
just a
question.
second. Oh, Mr. Lowry, did you want to field that? Go
Yeah,
ahead.
maybe I can help answer that question. So as Mr. Long addressed, at least one party in the case, and the party I think he's referring to is OPC, has specifically indicated that the company, based on the WEPCO decision that Mr. Long referred to, which was a NSR permitting decision that the company was aware of. I'm sure OPC would say the company should have been aware of it if it wasn't. But by failing to get what OPC's contention is that the company knew about the WEPCO decision. The company knew WEPCO didn't get permits but should have. And they contend that the Rush Island projects were similar, the circumstances were similar, and that therefore told the company it should have got NSR permits. In other words, the company was unreasonable for not getting NSR permits because of the WEPCO decision. And then based on that, OPC proposes a $34 million disallowance in this case. Well, I think to rule on OPC's contention that we were unreasonable for not getting the permits because of WEPCO and that $34 million should be disallowed, you've got to make the decision about whether we were reasonable in our permitting decisions made in 2007, 2010. The other thing you obviously have to do, I think, as well, is you have to find that the retirement decision that was made in December 2021 was reasonable, that it was reasonable for us not to scrub the plant and to retire it instead when faced with the court's decision that had been upheld by the Court of Appeals that we had to install scrubbers, and our conclusion that it was not in the best interest of our customers to spend hundreds of millions of dollars on scrubbers, and it was better for customers to retire it instead. So I think those are the two prudence-related decisions that the Commission needs to make in this case.
Okay, Mr. Lowry, I'm going to expound on that for just a second. In regard to the NSR decision, or the decision to not seek new source review, is that a decision in regard to whether to securitize, or is that a decision in regard to whether there should be a disallowance?
Well, OPC is asking that you deny securitization of $34 million based upon alleged unreasonableness or imprudence around those NSR permitting decisions. So OPC is making it an issue around the securitization. They are saying do not securitize that $34 million because the company acted unreasonably and prudently 12, 15 years ago. So that disallowance proposal and the basis of it has made that an issue in the securitization case. I don't really see any way around that.
Are those the only 2 points at which you believe the Commission needs to make a reasonable and prudence decision?
Those are the only two that come to mind. Yes, Your Honor.
Thank you. I see these words lumped together both in testimony and in the statute. It says, I'm going to just read directly from the statute. Where such early retirement or abandonment, and this is regards to energy transition costs, which is 1 sub 7 under 393-1700 RISMO. And it says in regard to energy transition costs that you can apply for pre-tax costs for abandoned or to be retired facilities where such early retirement or abandonment is deemed reasonable and prudent. Is there a difference between reasonable and prudent? Why are both of those together?
It's a very good question. I don't think there is a difference. If you look at the Commission's jurisprudence on prudence and you look at the Court of Appeals, and I don't know if the Supreme Court's addressed it, but the Court of Appeals has addressed the standard many times. The terms I think are used interchangeably. The definition of, and I think if you look at your Liberty Order where you most recently sort of laid out the prudence standard, I think the sum and substance of it is that you act prudently if you acted reasonably under the circumstances given what you knew or should have known, or conversely, you act imprudently if you act unreasonably under the circumstances. So I think they are really, two sides of the same coin. And I think the language in the statute just reflects that that's how the prudence standard has been applied for I think many decades in Missouri.
Bear with me just one moment. What would you say is the biggest difference between Ameren's position and, say, staff's or public counsel's?
On these prudence questions, Judge?
Yes, on why this issue.
I think with respect to staff, as Mr. Long indicated, Mr. Majors does actually indicate that he believes that the company acted imprudently back in 2007 and 2010. But his sole basis for that is simply an opinion that if you're found to have violated the law, that's sort of per se imprudence. And of course, we disagree with that. I think that fits the prudent standard at all. But he certainly, he even doesn't, on the basis of what we knew or should have known, claim that we were imprudent. Staff witness Eubanks doesn't reach the decision or the opinion that the company acted imprudently back then. But the reason I believe that she doesn't is that she doesn't believe that any harm has been shown at this point, and she collapses the prudence inquiry, the prudence question into both the question of the reasonableness of the action and whether there was harm. And if you don't have both, I believe, based on the questions that I asked her in deposition, I believe what she would say is, if you don't have both, you really don't have imprudence at all. You haven't gotten there yet, I think would be her opinion. Our view of prudence, and I think if you look at the law surrounding it, is they're in two inquiries. You can have acted imprudently but not hurt anybody. You could have imprudently run a red light but not actually hit any car and hurt anybody, so there's no damages. That doesn't mean you were reasonable when you ran the red light. So I think they're two different questions.
Hey, Mr. Lowry, this is the court reporter. Will you please speak up? You're going in and out for me. I don't know what it is. I hear everybody else fine.
Okay, I'll try to do better. In terms of the decision,
Ms. Richardson, are you catching his? I mean, have we lost any of what Mr. Lowry has said?
I believe that I've caught it all, but I noticed just over the past minute, I would say, him going in and out, and that's why I interrupted.
Okay.
I hope I haven't not heard something. I've heard everybody else. He's the only one I'm having difficulty with.
Okay, thank you.
Lean back a little.
See, now you just went out right there, and I couldn't hear a word you said when you were speaking. Did you hear him right then?
I did not.
I don't know what it is, and I don't mean to be disruptive.
Ms. Richardson, if you'll hold on for just a moment. Mr. Lowry, will you go ahead and speak again? I can't hear you at all. I don't know whether.
Can you hear me now? Can you hear me now, Judge?
Yes, I can.
Well, I'll try to make sure I lean into my microphone more directly. In terms of the question of the retirement versus retrofit, I don't think that staff is of the opinion or has not expressed the opinion, or I don't believe they are prepared to express the opinion that the company's decision was imprudent. Staff has raised some questions about the completeness of the analysis that the company did around that retirement versus retrofit decision, but I don't believe staff is contending that the company's decision was incorrect or that the retirement should not have happened. OPC's position on that, I think, is less clear to me. But as our evidence indicates, both analysis done at the time and analysis done since then in response to claims that I think have been made, at least implied in this case, that the company perhaps didn't make the right decision. The evidence is undisputed, I think, that customers are far better off not investing hundreds of millions of dollars or $1 billion or whatever it would be in scrubbers and retiring the plant than they would have been to invest that money and keep the plant open. So I think there is certainly, I think there's a difference of opinion about it, or at least a lack of surety about it. But I think it's not entirely clear exactly where the other parties are on that at times.
Okay, thank you, Mr. Lowry. The last thing I have at this point in time is not a question, but Mr. Long had indicated in regards to the 2017, 2019, and 2021 district court decisions that the commission ought to take a look at those. I believe somewhere in testimony, I saw the 21 decision. I'm not 100% sure. What I want to know at this time is, are there any party objections to the commission, taking the 2017, 2019, and 2021 district court decisions as commission exhibits in this case and admitting those onto the record for the commission's consideration. Are there any objections from any of the parties?
I believe that at least two of them are included in pre-filed testimony. Mr. Long probably knows that for sure. Maybe one of them is not, Mr. Long.
I believe they are all part of the record already.
Okay, I know I remember seeing the 21 decision, I thought. I'm not sure on the 217. I will hold on that for now. I'll take a look at the record and see if those are in there and watch to see if those are admitted. And I may come back to this question on a future witness. All right, I have no further questions based upon my questions. Are there any questions the commission would like to ask at this time? I hear none. The next mini opening that I have is from the staff of the commission. Ms. Mers, are you ready?
Good morning. My name is Nicole Mers, and I represent the staff of the Missouri Public Service Commission. The parties believed it would be helpful to give a brief primer of this issue before taking Ameren, Missouri's witness Homestead today. My understanding is that Mr. Homestead is solely testifying on prudence issues, which are stated as follows. Is it reasonable and prudent for Ameren, Missouri to abandon or retire Rush Island during September 1st through October 15th of 2024? And did Ameren, Missouri make reasonable and prudent decisions respecting whether to obtain new source review, also known as NSR, permits prior to either or both of the 2007 and 2010 Rush Island planned outage projects, and afterwards, including its conduct of the NSR litigation? If any of these or any of its decisions in this regard were unreasonable and imprudent, did any such imprudent decisions cause harm customers, and if so, in what amount? So that being so, I will primarily address this issue, and I reserve addressing the other subpart on the allocated day for it. So staff does believe that Ameren, Missouri's decision to comply with the district court's modified remedy order to retire Rush Island's plant no later than October 15th in 2024 is reasonable and prudent. However, staff does not believe it was prudent or reasonable to make decisions that led to violations of federal law. Throughout the district court opinion, as upheld on appeal, the district court found Ameren, Missouri knew or should have known the improvements at Rush Island would trigger NSR. This conclusion is not based on a hindsight analysis. Furthermore, as evidenced in the transcript filed by Ameren, Missouri on April 8th, 2024, beginning on page 25, line 17, through page 26, line 6, Mr. Quinn, on behalf of the United States, stated, I think it's evident from the filings that Ameren has struggled to accurately... Is there a question? Struggled to accurately convey these proceedings to the MPSC, and has now also struggled to fully wrestle with that failure before this court. I believe the examples I just provided to the court speak for themselves. But I think, suffice it to say, contradictions abound between what's been said to the MPSC and what this court has said. And you'll see, Ameren has sort of painted itself into a corner to the MPSC. The company is committed to maintaining its position that it's never done anything wrong. But in these proceedings, of course, we know that this court and the Eighth Circuit have said Ameren did make a big mistake, and one that cost people their lives. The court then responded on page 32, line 22 through page 33, line 8 of that same transcript. I mean, it is what I said in my opinion, that a decision was not reasonable, and that's not mentioned anywhere to the PSC. In fact, Ameren continues to take the position that despite this court's findings, and its findings be affirmed in all respects by the U.S. Court of Appeals, the decision was not reasonable. You went to the PSC and you told them that it was. That's fine. What I'm going to ask you to do is to order a copy of today's transcript and send that to the PSC for them to evaluate it however they see fit based on their standards. And they'll make their own decision on this basis. So the court is adamant that Ameren, Missouri made mistakes and took unreasonable actions. As outlined in the rebuttal and sub-rebuttal testimonies of staff witnesses Keith Majors and Claire Eubanks, the court findings were thorough and well supported in coming to this decision. However, the harm is not fully known to customers. And that's not known for us to provide to the commission because the court is considering additional remedies, which was also discussed in the transcript from the status hearing that was conducted a few weeks ago on March 28th, 2024. It is staff's position that any additional remedies related to Ameren, Missouri's litigation on Rush Island be borne by Ameren, Missouri, and not its customers. The proper place for those prudence adjustments would be in subsequent rate cases where Ameren, Missouri proposes to collect cost related to those additional remedies. Staff raises the issue now to preserve it for those future hearings. This issue is heightened by a statement in the transcript Ameren, Missouri filed in this case on April 8th, 2024. The United States posits a potential $275 million in remedies for the damage done by Ameren, Missouri. This amount is highly concerning to staff. On top of transmission upgrades, which are discussed by staff witnesses Sean Lange and Claire Eubanks, this also does not include the potential short-term capacity shortfall that may occur before replacement of Rush Island's capacity. Staff witness Claire Eubanks can explain in more detail how these recent facts further support our recommendation to hold Ameren, Missouri's customers harmless for those additional remedies due to their court-determined unreasonable action in regards to the permitting process. Thank you. I'm happy to answer any questions you have. Otherwise, I urge you to ask Claire Eubanks, Sean Lange, Red Fortson, and Keith Majors questions when it is their turn on the stand.
Thank you, Ms. Mers. Are there any commission questions for this attorney? Okay, I've got a few. I'm going to start with the thing that kind of stuck out to me immediately, Ms. Mers. And you indicated that staff is bringing up this issue. You said that any harm would be addressed in a future rate case. Is that correct?
Yes.
And that staff is bringing this issue up at this time to preserve it. What do you mean by that?
Well, I think we even heard it in the opening this morning that often we're accused of using hindsight if we would wait to that rate case to explain our issues with the decision-making process. So we wanted to document thoroughly why we believe that those remedies should not be borne by the customers and put Ameren on notice that that was a position that we were going to take.
Okay, well, isn't that always the case though? Aren't you, when you're looking at prudency evaluations, aren't you always, I mean, when you're looking at the decision at the time and what was known, but from the perspective of the commission, nobody's asking the commission to issue an advisory opinion, which the commission could not do, but nobody's asking this decision we're about to make, is it prudent? We're always looking back on these decisions. We're always dissecting them in the past and asking ourselves what was known at the time. So why does it make a difference whether it's here in a rate case?
Well, when we know the final harm figure, that's the only time that we can actually make that disallowance. Then without a firm factual number, we can't do it till those subsequent rate cases. And we often get hearings derailed by accusations of using hindsight or Monday morning quarterbacking from the utilities. So again, it's just a way to address that potential.
And I can certainly see from staff's point of view wanting to get that out there. So thank you for explaining that to me. Now staff based upon the NSR permitting is asking for a disallowance. Is that correct?
We are not,
Is that only OPC?
yeah, that's
sorry
only
to interrupt.
OPC. There's an potentially in-camera disallowance that I think we're making, but it's not related to the securitization amount.
Okay. Are we muddying, are we kind of muddying up this issue here? Because the way I read the statute, the statute only mentions prudency in regards to energy transition costs as to the decision to retire the plant. You've indicated that the district court has made no determination on harm or damage at this time. And my understanding is that Ameren was recently ordered to, I believe on March 14th, provide their potential remedies. So if we make a decision in regards to an NSR thing, whether it be a disallowance or otherwise, are we stepping on the district court's feet? Especially if we're going to be evaluating this in a future rate case, when if there's harm, that harm might be more known.
I don't believe we would be stepping on the district court's jurisdiction or their decisions on what remedies to order. It's clear through those three cases that the court was very unhappy with how Ameren approached the permitting process and the decisions that they made, and that they believed it to be very unreasonable, and that frankly they need to take responsibility for those actions. So holding customers harmless is a way to do so and still effectuate the district court's orders.
Okay, and I believe we'll get into the hold harmless proposal with Ms. Eubanks, correct?
Correct.
Bear with me for just a moment. I guess I'm going to ask you the same question that I asked Ameren's attorney, and I think what I've set up so far is an appropriate lead into that question, and that is, what reasonable and prudent decision does the staff of the commission believe the commission needs to make in this case?
If the commission were to find that the decision-making process of Ameren, Missouri was not reasonable or prudent, then they could approve or suggest the hold harmless be implemented in the future, and that Ameren's on notice that whatever cost those are, when those are known, just won't be borne by customers.
Okay, is this a fair assessment of staff's position? I heard you say that staff is of the opinion that at the time, and I assume it's 2021, when Ameren made the decision to seek leave of, or seek a modification of the district court order to retire the plant, as opposed to putting on what I'm going to call the pollution scrubbers. I heard staff say that they were of the opinion that that was a reasonable and prudent decision to retire that plant, correct?
Correct. Yes, staff believes that Ameren is kind of in a mess of its own making, but now that we're in the situation that we're in, what is best for customers is retirement and securitization of the plant.
Okay, those are all the questions that I have at this time. Based upon questions I've asked, are there any additional commission questions?
Yes, Judge, I have one.
And thank you, Chair Hahn. And I'll just say, anytime commissioners have a question, please feel free to interrupt me.
Thank you. Good morning.
Good morning.
Thank you for being here today. I do have a question based upon Judge Clark's questions. Just to clarify, with regard to issue 3A, does staff believe under the statute that the commission has to determine the reasonableness and prudency of obtaining the NSR permits in this case? Or is that only in this record because you're trying to preserve it for a future case?
Trying to preserve it for a future case. Because the remedies would not be securitized cost, that, a hold harmless provision on that wouldn't impact staff's recommendation on the total amount to be securitized in this case.
Thank you. Appreciate that clarification.
No problem.
Thank you, Chair Hahn. Are there any other commission questions at this time? Hearing none, thank you, Ms. Maris. Thank you for your mini opening.
Judge Clark, it strikes me that the filing that Ameren, Missouri made on April 8th, the transcript that I referenced, is in EFIS but not in the record. Could I request that have official notice be taken of those transcripts that Ameren submitted?
You said official notice of another court's transcript, correct?
Correct.
And I'm a little puzzled because I'm not sure whether we can do that or whether it's appropriate in regard to another court.
Judge, this is Jim Lowry. I mean, I don't know what our position might be on that. I share your question about what an official notice is really appropriate. If the commission wants to entertain that motion, I would, I guess, ask for us to have the opportunity to perhaps take the issue up Monday, but us to have the opportunity to at least consider whether or not we think that's appropriate or not.
I'm going to agree with you, Mr. Lowry. I'm not opposed to staff's request. I honestly just don't know the answer to the question off the top of my head. So I would like an opportunity to look at it too. So why don't I will make a note. To take this up Monday as a preliminary matter.
Thank you.
And that will give me an
Company
opportunity.
opposed either. I'm sorry. I thank you, Judge. I don't know that the company's opposed either. It's just not something we've contemplated. So
Yeah. And I'm debating in my head whether this is something that would be more appropriate to take notice of or to have as an exhibit, or whether it even matters. We will, like I said, I've made a note and we will discuss it as a preliminary matter on Monday. Thank you, Ms. Maris.
Thank you.
Next up for mini opening, I believe I had MIEC, Missouri Industrial Energy Consumers Group. Let me see that that's right. At the time, there was no attorney here. At the time, there was no attorney here from MIEC. Is there an attorney from Missouri Industrial Energy Consumers Group here now? Okay, I hear none. Next mini opening is from AARP.
Thank you, Your Honor. We'll reserve the bulk of our comments for Monday with the general opening, but I did want to make one comment in response to what I heard from Ameren counsel, Jim Lowry, on the standard, the prudent and reasonable standard. I have a slightly different legal take on the standard. I believe that the courts have treated each of those as somewhat separate in cases, in certain situations, noted that an action could be prudent and yet deemed unreasonable in a particular case under the facts of those cases. So I think that there's a reason that just and reasonable, it's also separate, but also prudent and reasonable are sometimes a separate substandards that are reviewed by the commission. But we can brief that, and just wanted to state that for the record, and we'll defer any other comment until the case begins on Monday. Thanks.
Thank you, Mr. Kaufman. Are there any questions for Mr. Cobb for AARP? I have one. So it's listening to what you said. We heard previously somebody said that they're the same or similar or related. And what you're saying is, giving a literal reason of reading of the statute, it's both reasonable and prudent, and it must be both of those as individual standards. Is that correct?
Right. Yeah. Sometimes they're mentioned together and sometimes they're not. But yeah, I don't think that they're collapsible. I think they can mean different things in certain situations.
Okay. Thank you, AARP. Any mini opening from Midwest Energy Consumers Group, or MECG?
No mini opening for this issue, Your Honor.
Thank you, MECG. Any mini opening from Renew Missouri?
Thank you, Judge. I will reserve our opening and reflect our positions in this case for Monday. Thank you.
Okay, thank you, Renew Missouri. Any mini opening from the Office of the Public Counsel? Mr. Williams, I can't hear you. I don't know whether you're muted or whether we're having an issue again. And just so everybody knows, in case
Whoa. Can you hear me?
I can hear you, and that was
Okay,
quite so.
I'm going to call again.
I can hear you just fine, Mr. Williams.
I'm going to call again.
Okay. And I think the issue is that Mr. Williams can't hear me.
Welcome to WebEx. Enter your app. Enter your attendee ID number.
We can obviously hear his microphone calling in, so when he does,
Hold on just a second. Ms. Richardson, can we strike all this background stuff? I don't really want it in the transcript in regards to.
Didn't put it in the transcript, sir. The back and forth, normally they don't want us to do that, but when it's something like this, internet issue.
Thank you.
No problem. But when he comes back on and he starts speaking, we go back on the record, right?
That's correct.
Okay, thank you.
Can you hear me now?
Yes, Mr. Williams. You hear me?
Okay. Yes, I'm not sure what happened, but in any event, it sounds like we're okay. Originally, I did not plan to give a mini opening at this point, but after listening to Ameren, Missouri, I think it's appropriate to do so. The first thing I want to point out is that the EPA has started an enforcement initiative with things like the prevention of significant deterioration in air quality back in 1999, which you may note is towards the end of the Clinton presidency. And then G.W. Bush became president in 2001, and I'm expecting the record will reflect that the enforcement activity slacked off a bit. And in 2005, the EPA actually set out a proposed rule, my understanding, that would conform to what the Missouri Department of Natural Resources state implementation plan has in terms of measuring emissions, actual emissions for an hour, and then using historical and using that as the standard by which you would measure what would happen afterwards. Much of what Mr. Nash related about the Missouri state implementation plan was, as he said, MDR's interpretation and certainly Ameren, Missouri's interpretation, but it was not the law, as Judge Sipple found it is not, was not. It is a plain reading of that regulation in a certain fashion, but I think given in light of the enforcement activities at the EPA, it was in the history of the industry, the utility industry, trying to minimize the impacts of EPA actions and effects of their regulations and the Clean Air Act, and that goes back to when the Clean Air Act was first put into law back in the late 70s. And the federal interpretations are done with effect to the intent of the effect, not just the literal language of the law or the regulation. I think it's kind of a forced reading, so to speak, but it's not untenable, wholly untenable. Our position is that basically Ameren, Missouri should have gone to the EPA Enforcement Division and asked for a applicability determination, which would be legally binding on that EPA afterward, is my understanding, so that if the EPA said, no, the Missouri SIP doesn't get you out by the way you're reading it, the utility would have known that. It still would have had a choice about whether it wanted to comply with the EPA's determination or if it would have decided to go forward. Basically, in 2005 timeframe, well, by the time we got to 2005, Ameren, Missouri knew that Rush Island was having a lot of pluggage issues and was requiring a lot of outages in order to clear those. And that's when it made the decision to replace a number of components to address those pluggage issues. Given that knowledge and well, I don't think it's pure coincidence that the EPA enforcement action against Ameren, Missouri at Rush Island did not start until the Obama administration after 2009. But given the history, it's our position that Ameren, Missouri was not prudent in its actions about its decisions going forward, and it really had 2 or 3 options at the time. It could have shut down Rush Island. It could have kept operating it with what the EPA would accept as routine maintenance and repair, or it could have gone ahead and made the upgrades it did, plus added the emissions requirements that it did not do, that Judge Sipple ended up deciding it was required to seek permits for. As to the prudency issues, the statute gives an alternative to traditional rate-making approaches for potential cost recovery of Ameren, Missouri's investment in Rush Island and its costs associated with retiring and shutting down the plant. Prudence is a gateway to getting securitization. When prudence has been evaluated in the context of a rate case, the reason for requiring harm is because it was a meaningless determination otherwise. In other words, if the commission found there was imprudency but no harm, there was no relief, so there's no point in determining prudency to begin with. So we believe it's a gateway. Harm is not necessarily a component of it. However, it's our position that Ameren, Missouri shouldn't be recovering through securitization if it's given any more than it would have in a rate case. It should not be more costly to customers. So the traditional prudency analysis does apply for purposes of what amounts of energy transition costs should be securitized. I'm working off the fly here, but I think that covers the points I wanted to get across in response to what I've heard in the other openings, and I'd reserve the opportunity to expand more during when this issue's taken up again Monday or whenever it is. And I'm happy to try to answer any questions.
Judge Clark, I think you're on mute.
I've enjoyed this little conversation I've had with myself for the last 30 seconds or so, and I'm sorry everybody else had to watch me mime like a puppet. But Chair Hahn, thank you so much for letting me know. I was completely unaware I was still muted. What I was going to say is, are there any commission questions for this attorney at this time?
Yes, thank you, Judge. Good morning, Mr. Williams.
Good morning, Chair Hahn.
I'm going to also ask you the same question that I asked Staff Counsel Mers. So Staff Counsel Mers mentioned that she did not believe the commission had to make a determination on issue 3A on prudency determinations on whether to obtain the permits. I think I heard you say you think that the commission does have to make that determination because it goes to the amount that could be securitized. Is that your position, or is it something else?
That, in fact, is my position, and the commission, I think, could consider it in the context of even potentially whether it's appropriate for Ameren, Missouri to be shutting down Rush Island in the future. And the rationale behind that is if Ameren, Missouri was imprudent in the past and should have put on scrubbers then we view it probably would be, it's unlikely that it would be appropriate for it to be shutting the plant with scrubbers down now. But I'm not sure we're not sure there's going to be enough evidence in the record to make that prudency determination.
That is helpful. Thank you so much.
You're welcome.
Are there any other commission questions for this attorney? I hear none. Can you clarify that for me when you say you're not sure there's enough evidence in the record? I'm not following you. Does this get back to the harm determination? Or is this something else?
What I was getting at is determining what avenue would have been prudent for the utility to have taken back in the 2007, well, actually it's 2000s timeframe. I mean, the original go ahead, I think, was 2005, but they've known they were having plugging issues at Rush Island long before then. It goes back to the 90s whenever they switched from low sulfur or high sulfur coal to the low sulfur, dirtier Powder River Basin coal. But the issue is if you'd have to determine the prudency of which route to go. And if, let's say you make a determination, I don't know that you can decide which one was the appropriate route in terms of shutting down Rush Island, then running it for a bit longer until it became so uneconomic that you just shut down the plant, or if you would make the upgrades that they did make, plus add scrubbers, or go the route that Ameren, Missouri chose to go. I don't know that the record's going to be sufficient to decide which of those was prudent or imprudent. And those, depending on which one was which avenues were not imprudent, would lead to different circumstances in the present. Because if the appropriate thing to have done back in the early 2000s was to have added scrubbers as well as do the upgrades that Ameren, Missouri did put in place, that's a much different plant in 2024 than the plant we have now, because the scrubbers would already be there. And of course, you would have avoided all the federal litigation as well. But I'm not sure there's going to be enough evidence in this record for the commission to make that determination.
Given that the district court is still determining remedies, is it even appropriate for the commission to make a disallowance that might be considered punitive in nature?
I don't see any issue with it. The remedies is for failure to, my understanding of the remedies at the federal court are failure to comply with the EPA regulations. Federal law.
Now OPC, and I've heard the word, I apologize, go ahead.
I'm sorry, EPA requirements.
Now, I heard it tossed around before in one of the openings that the term 34 million. Is that the value of this issue to OPC?
That is a quantification we put out there through a witness.
And OPC doesn't believe granting that disallowance would step into the bounds of the federal court and their remedy determination.
I'm sorry. I believe they're independent. And let me elaborate a bit. The federal court's looking at a remedy for the harm that was caused by the emissions from the plant in the past. What the commission's looking at is what's fair recovery for the utility after the plant's no longer being used to provide service to customers.
Does OPC have an opinion as to whether it was prudent to retire the plant in 2021 or to make that decision in 2021?
Not at this time.
It doesn't have an opinion? Is that correct?
You saw our position statements. We think we need to look at all the evidence before we can opine on that.
Okay, just asking. All right, thank you, Mr. Williams.
Thank you.
That is all I have down for mini openings for parties that are here. Are there any parties that I have missed that wanted to make a mini opening on this issue? Okay, I hear none. It is 10:38. It was my intention to take a break around 10:30 for about 10 minutes to give everybody a chance to use the bathroom or whatever else during a 10-minute break. Is 10 minutes going to be sufficient for everybody? I don't hear any objections. It is 10:38. I'm going to treat that as 10:41. We come back at 10:50. And we will go off the record now and recess for roughly 10 or 11 minutes. Okay, Mr. Lemons, if you want to go ahead and take the intermission off, thank you. Before we go back on the record, I wanted to ask before I leave today, unless somebody knows now, can somebody tell me where the district court or whose testimony the district court's decisions are attached to, so I can verify that? And if anybody,
Judge Clark, this is Nash Long. I believe they're attached to Mr. Major's testimony.
all three of them? Ms. Merritt, you can
My
answer.
memory is failing.
Sorry, Judge, let me confirm. I recall that some were attached, but I'm not sure if all three were or if it was just a selection of them. So let me confirm that for you.
I don't want to unnecessarily delay things before we start back up, but I would like to know that.
So my understanding is the remedy order is not attached, but the other two are.
Now, the remedy, that's the 2019, correct?
I believe so.
Okay, thank you, Ms. Maris. All right. I will come back to that on Monday also as a preliminary matter. Let's go on the record now. All right, we are back from a short recess. At this time, Ameren, if you'd like to go ahead and call witness Homestead.
Thank you, Your Honor. And Mr. Homestead is right here in the conference room with me, and we'll just change places, and then he can be sworn in for his testimony.
Mr. Homestead, good morning. Would you raise your right hand to be sworn, please? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes, I do.
Thank you, Ameren. Go ahead.
Can you please state your name for the record, sir?
Jeffrey R. Homestead.
And are you the same Jeffrey R. Homestead who prepared for filing in this docket both direct and rebuttal testimony?
Yes.
Marked for identification as exhibits 10 and 11?
Yes, I am.
And do you have any corrections to either exhibit 10 or 11, your testimony?
No.
And if I pose the same questions to you today, would your answers be the same as reflected in your direct and rebuttal testimony?
Yes.
Are those answers true and correct to the best of your knowledge and belief?
Yes.
Your Honor, at this time, Ameren, Missouri will move exhibits 10 and 11 into the record.
Are there any objections to admitting the testimony of Jeffrey Homestead, Exhibit 10, his direct testimony, and Exhibit 11, his rebuttal testimony, onto the hearing record? I hear no objections. Exhibit 10, the direct testimony, Exhibit 11, the rebuttal testimony of Jeffrey Homestead, will be admitted onto the hearing record, and you may continue your direct examination, Mr. Long.
Your Honor, at this time, Ameren, Missouri tenders Mr. Homestead for cross.
Thank you, Mr. Long. Because this is an Ameren witness and going by the order of cross-examination submitted by the parties, are there any questions for this witness by Renew Missouri?
No questions. Thank you, Your Honor.
Thank you, Mr. Linares. Are there any questions from MECG?
No questions, Your Honor.
Thank you. Any questions from not the Sierra Club, they've been excused. Any questions from MIEC? Do they have an attorney here yet? Any questions from AARP?
No questions, Your Honor.
Thank you, Mr. Kaufman. Any questions from consumer councils?
No questions.
Thank you, Mr. Kaufman. Any questions, any cross-examination from the commission staff?
No, thank you.
Any cross-examination from the Office of the Public Counsel? I'm sorry, Mr. Williams, I can't hear you. I still cannot hear you. I will wait.
Mr. Williams, you may have to hit *6 to unmute.
Can you hear me now?
I can, Mr. Williams, go ahead.
Okay, thank you. I do have some questions. Good morning, Mr. Homestead. How are you?
I'm fine, thanks.
Isn't it true that the EPA's Division of Enforcement ramped up enforcement activities against utility emissions on or about 1999?
Yes, that is correct.
And in your direct testimony, you talk about, in the early part of it, you talk about what the law is in Missouri under the Missouri Standard Implementation Plan as set out in the DNR regulations. Do you not?
Yes, I do.
And that starts on page 11?
I don't recall, but that sounds about right.
And in your testimony there, you stated as if that is or was the law. Was it in fact the law back in the early 2000s?
So as I think you said in your opening statement, that what I provided there is the plain reading of the Missouri regulations, and that what the reading that I provided, I acknowledge that many years after the fact in 2017, the district court judge had a different interpretation. But certainly at the time of the projects, the interpretation that I lay out there, as you say, the plain reading of the interpretation is what MDNR believed the regulation said. It's what everybody in the state, all the industry. In fact, it's been interesting to me that no one in this case has provided any evidence that anyone had a different reading of the regulations before 2017, or I guess whenever the enforcement action started. But certainly in the 2005 to 2010, that's what
Judge, I think he's already answered the question and he's just going on now.
No, I'm sorry. I'm finished. I'm just trying to make sure I give you a complete answer.
Thank you. Appreciate that. But you agree that what Judge Sipple said the law was is what the law was?
Yes.
And aren't judicial interpretations of law binding on this commission?
I'm not quite sure what you mean by that. I don't think this commission has any jurisdiction to declare what the Clean Air Act requires. My understanding is the issue before this commission is whether the decisions that Ameren made were reasonable based on what it knew or could have known at the time. So
Well,
I don't understand why this commission would make any decisions about what the Clean Air Act requires.
Well, Ameren, Missouri is asking this commission to, I believe, determine that its understanding of the Missouri SIP and the Clean Air Act requirements was reasonable at the time it held that understanding back in 2005, correct?
That's my understanding. Is the issue is whether Ameren had a reasonable basis for believing that it did not need to get NSR permits. And so I guess in my view, what the court said in 2017 couldn't have been known or knowable. So what Ameren had to do was base its decisions on what was known at the time, and the reading that I've given, as you say, the plain reading of the statute is what they knew or could have known.
Well, is there anything faulty in Judge Sippel's analysis of the law?
No, I mean, so the answer is no. He's declared what the law is. The circuit court did overrule a big chunk of the remedy that he had ordered. But in terms of whether Ameren was required to get permits, no, what he said in 2017 is the law.
And it was in 2005, right?
But nobody knew that in 2005.
Well,
so I guess
that Missouri should have gotten a permit in 2005. Wasn't he declaring what the law was in 2005?
Yes, but
I'm
nobody.
sorry, this is the court reporter. I didn't get your question, Mr. Williams, because you guys were talking over each other a bit.
Sorry about that.
It's okay.
What I asked him wasn't Judge Sippel declaring the law as it was in 2005, in his opinions in the Ameren, Missouri Clean Air Act litigation that's dealing with Rush Island.
Yes, that's what he decided in 2017. But that was not knowable by anyone at the time.
And haven't utilities such as Ameren, Missouri consistently brought litigation with regard to emissions requirements since the Clean Air Act first became law?
You know, there's been hundreds of EPA regulatory actions and other actions. Certainly, some of those have been challenged by the utility industry. Like every other regulated industry, they have a right to challenge if they think EPA is outside of the bounds of the law.
And don't they have decades of history of doing that? And I'll point out the Utility Air Regulatory Group, for instance.
Yes, certainly.
And the litigation they were bringing was for more expansive interpretations of the law and regulations than the EPA, correct?
No, I mean, each case is sort of different. In some cases, they may have held a more expansive view, and others so what I think every case they brought, many of which they prevailed upon, they challenge EPA, some action that EPA has taken as either being unreasonable, either being arbitrary and capricious or outside the bounds of the law.
Have you ever represented anyone other than utilities in the federal government on Clean Air Act matters?
Sure. I've done, over the course of my career, I've represented companies and trade associations and nonprofit groups in a number of cases.
What compensation are you receiving for your time and work for Ameren, Missouri in this case?
I believe that's in my direct testimony. It's my standard hourly rate with sort of a discount. So I don't recall what the number is, but I know that that's in my direct testimony.
And do you know how much you billed to this point?
I do not.
Not even ballpark?
You know, no, I truly don't. I haven't paid attention. Again, that's certainly something that's knowable. It's a significant amount. There's no question about it. I've spent a lot of time making sure that I do my best to explain these issues in a way that everyone can understand. So there's no doubt it's a significant amount.
Does the EPA have jurisdiction to enforce provisions of the Clean Air Act and its regulations, regardless of what position a state may have taken on compliance with the act or those rules?
Yes. I will say it's unusual. I will say it's very unusual, but occasionally you have a case like this one where EPA disagrees with the state's interpretation of the state's own law, and EPA does have that authority under the Clean Air Act.
Well, didn't that happen in the WEPCO case? WEPCO?
No, actually, in that case, the state agency said it didn't know whether NSR applied, and it asked EPA to opine on the issue. It was not a case that in that case the petitioner was the power company. It was not the state.
On pages 8 to 10 of your direct testimony, you talk about a potential to potential test.
Correct.
What is the potential to potential test?
So, it sounds kind of deceptively simple. The question is whether there's a physical change at a plant that will cause an increase in emissions. But figuring out exactly what that means, does that mean, in the prior day compared to, the day before, the day after, the week before, the week after? And the easiest way to do that emissions increase test is what would be called the potential to potential test. You basically say, if the unit is running at its maximum capacity, what will the emissions be? Those are the potential emissions. And you can compare that before and after a physical change. And the idea is, if you're not changing the unit in a way that will increase its capacity to emit, then it doesn't cause an emissions increase. That's basically the potential to potential test.
Did the EPA ever adopt that potential test?
So in a related program, but the Clean Air Act is very complicated. There's the NSR program. There's another program called the NSPS program, and it has the same definition of modification. It says a physical change or change in the method of operation that results in an emissions increase. So that exact same language is used in both the NSR program and the NSPS program. In the NSPS program, it's a potential to potential test, and that's the test that under the plain reading of the Missouri SIP would have been sort of the initial question to ask.
Mr. Homestead, I feel like Mr. Williams asked you a question there, and you said this is where it also is at the EPA, but I don't feel that answered the question. Would you ask your question again, Mr. Williams?
Sure. Did EPA ever adopt the potential to potential test you just described?
Well, my answer is yes, they did in the NSPS program. But if your question is, did they ever adopt that in the NSR program, they did not.
Well, you've anticipated my next question, given your response to the prior one. Did it ever consider adopting it for the NSR program?
Yes, it did. I don't remember the year, but at one point they did propose that, and that rule was never finalized. I will say that issue has been around for a long time, and there were some courts who held that that was legally required because the NSPS program predated the NSR program, and since they had used the potential test in the NSPS program, there was a lot of litigation over whether EPA could have a different emissions increase test in the different programs. And ultimately, the Supreme Court decided that they could.
Well, is the, I think, proposed rule that you referenced, might it have been prevention of new source deterioration, comma, non-attainment, new source review, comma, and new source performance standards, colon, emissions test for electric generating units that was published at 70 Federal Register 61081 on October 20th of 2005?
That sounds right, yes.
That would have been shortly after you left the EPA, correct?
Correct.
Did you have any involvement in the development of that proposed rule?
I was certainly involved in conversations about that issue, in conversations about a number of things related to NSR, but I didn't really have a hand. So I certainly was aware of that issue and the interest in proposing that rule, but I was not really involved in the development of it.
Was the electric utility industry interested in that proposed rule?
I'm sorry, I didn't catch the question.
Was the electric utility industry interested in that proposed rule?
Oh, of course they were, yes. Yeah.
Were they pushing for it?
Yes, I'm sure they were. The potential test is a much more objective test to apply than what we currently have.
Turning to page 32 to 33 of your direct testimony, there's a bullet point there that includes how other utilities were interpreting the NSR regulations. In fact, Ameren received a detailed memorandum from UARG showing that other power companies had collectively made more than 100 component replacements were the same as or similar to the component replacements in the Rush Island projects. And that no one had sought an NSR permit for any of these projects. And then you say, see Schedule SCW-D6. You recall that?
I don't have that schedule in front of me, but I certainly recall that. I certainly recall making that point in my testimony.
Can you get that schedule in front of you?
Which one?
SCW-D6. So I think it's Steve Whitworth, direct.
Is it D6?
Yes.
Okay, yes. Yeah, no, actually, I do have that right here.
And that is a confidential schedule according to Ameren, Missouri, correct?
Correct. That's what it's marked.
We'll probably need to go in camera for his response, but not for the question. Would you identify the projects on Schedule SCW-D6 that you say comprise the more than 100 component replacements were the same as or similar to the component replacements in the Rush Island project?
So what I will say is this lists 21 companies.
Mr. Homestead?
Yes.
Are we in any danger here of going into confidential information?
I don't think so. I don't think so. If it approaches anything like that, I will certainly. It will depend on the question. But if he's asking just sort of generally about these issues, I don't think we need to treat it as confidential.
Well, I'm asking for the specific projects in that schedule that you are identifying as being similar, the same as this or similar to the component replacements in the Rush Island projects, and we're talking about the 2007 and 2010 project.
Right.
So
every one of these cases, every one of these plants involves the replacement of major components. That's what all of these. That's what this is designed to do. So I don't, there's reheater replacements, there's economizer replacements, there's boiler tube replacements. There's preheater replacements. I don't have listed here precisely what the components were, but every one of these involved the replacement of major components. And there are 21 companies. I will note that the federal government's own utility, the Tennessee Valley Authority, had 9 plants where they had replaced major components without getting a permit. Altogether, there's over 100 on this list.
Would you turn to, well, on page 56 of your direct testimony, you testify that the district court did not find that Ameren, Missouri did not have a reasonable basis for believing that the Rush Island projects were the type of projects routinely done in the industry. Is that not correct?
No, what I said was correct.
Well, is what I said correct statement of what you said?
I'm sorry, you'll have to read it to me again.
Sure. On page 56 of your direct testimony, you testify that the district court did not find that Ameren, Missouri did not have a reasonable basis for believing that the Rush Island projects were the type of projects routinely done in the industry.
That statement is absolutely correct.
Are you familiar with the court's...
Would you repeat the question and answer for me there, please?
You talking to the court reporter?
Yes, I'm sorry, Ms. Richardson, would you repeat that question and answer for me?
Just a minute, I have to read it, and then just 1 second. Okay, it says on page 56 of your direct testimony, you testified that the district court did not find that Ameren, Missouri did not have a reasonable basis for believing that the Rush Island projects were the type of projects routinely done in the industry. That statement is absolutely correct.
Thank you. Sorry for the interruption. Go ahead, Mr. Williams.
Mr. Homestead, are you familiar with Judge Sippel's 2017 liability opinion that is referenced as Ameren 3 in the 8th Circuit opinion on appeal?
Yes, I'm familiar with those decisions.
Are you familiar with the findings of fact that appear on, well, let me give the finding of fact numbers instead. Findings of fact 174, 175, and 176 in that opinion?
Not off the top of my head. I don't know if that's something you could show on the screen, or I could try to find it here.
I'm not sure which will be quicker because they're rather lengthy if I try to read it. I don't know about
Okay, well,
let
me see if I can.
Mr. Williams, what findings of fact?
174, 175, and 176.
Okay, 170. Okay, I've got it.
Didn't the court make some specific findings with regard to the projects and how typical they were in the Ameren, Missouri projects in 2007 and 2010, and how frequent they were in the industry?
So what he found, I think he actually makes a finding here in 174 that projects such as the economizer, reheater, air preheater, and lower slope replacements are not performed frequently during the life of a particular plant. So it is true that if you look at a particular unit, that unit doesn't replace them very often. Like a particular unit will only replace those, every 20 years or something like that. Within the industry, there are hundreds of those replacements that have been done, and that's the point that I'm making.
Well, take a look at
and actually, I do remember this finding of fact number 16. I'm sorry. 170, I'm sorry, this is 175. He says that the expert was not able to identify any coal-fired unit in the electric utility industry that has replaced the economizer, the reheater, the lower slope, and the air preheater together. So what he says there is, well, utilities may have replaced these components many times, but that particular combination that the expert, couldn't identify one that replaced those exact same things all together at the same time. But he doesn't refute the fact that, or disagree with the fact that these types of projects were done routinely more than 100 times throughout the industry. And that's the point that I make in my direct testimony. And there's nothing in this finding of fact that refutes that.
So you're drawing a distinction between, I guess, the subparts of the projects as opposed to the entirety of the projects of what Ameren, Missouri did in 2007 and 2010?
Yes, but certainly other utilities had done collections of projects at the same time. They may not have done the exact same combination as what Ameren did, but it's not just that they replace one at a time. Utilities frequently replace more than one at a time when they're in an outage, because that's the most effective way to do it.
Well, let me just read finding 175. Even looking exclusively to how common work is performed across the utility industry, Mr. Golden was able to identify few, if any, projects that rival the 2007 and 2010 major boiler outages at other Ameren plants or elsewhere in the utility industry. Mr. Golden has worked on 14 NSR cases since 2000 on behalf of electric utilities. Then there's a cite to his testimony. During that time, he has collected a list of 18,300 projects undertaken at coal-fired power plants that he says are both capital projects that cost more than $100,000. Again, there's a cite to his testimony. However, Mr. Golden was not able to identify any coal-fired unit in the electric utility industry that has replaced the economizer, the reheater, the lower slopes, and the air preheater together. And then there's a reference to someone's deposition, VASEL, was in a parentheses, unable to recall any other outage at Ameren when all components were replaced. Have I accurately read finding 175?
Yeah, and I think that's what I was just explaining. That so the point is, and I don't, in terms of companies that had done those specific projects all together, Mr. Golden was not able to identify those. And that's, again, I don't think anybody disputes that hundreds of these projects have been done throughout the industry, and no one has ever sought an NSR permit for them, for these component replacements, even when they're doing, several at a time. Now, I think the point that you're making is, well, he did say that he didn't find that many where during one outage they had replaced, an equal number of components, but there certainly are examples of those. There's a couple even in Missouri where the state looked at a big project. There was one that Mr. Whitworth mentions in his testimony, where the state specifically found that even though they were spending $70 million to replace a bunch of components in one outage, that they didn't need an NSR permit.
Well, let me read his finding 176. Similarly, even for the relatively few air preheater replacements that Mr. Golden did identify, 35 out of approximately 1,200 coal-fired generating units operating in 2007, Mr. Golden was unable to testify that all were complete replacements or were comparable to those at Rush Island. Have I read that correctly?
Yes, you have. So there were 35 other units where the preheaters, the air heat
Judge,
preheater replacements were done.
Are you
He's
making
just
an
reading
objection,
what
Mr.
I
Williams?
read. I asked that that part of his answer be stricken. He answered the question when he said that I read it correctly. And he's just repeating what I said, essentially.
I'll grant that. You can go ahead and strike the portion.
So on Schedule SEW-D6, how many of those involve air preheater replacements?
I don't know. I don't know.
Did you create Schedule SEW-D6?
No, I think this was included in Mr. Whitworth's testimony to demonstrate that they were aware. So this was, I think, dated 2007, and I think he was using it to demonstrate that Ameren was aware that hundreds of these similar component projects had been undertaken without permits. I didn't create it. It's from a document.
Do you know the source of it?
Yes, it was a document that UARG, which is what we call the Utility Air Regulatory Group. So so it was a confidential memo from UARG to the UARG member companies.
Go to page 61 of your direct testimony. There you state, and I'm quoting right here, I have had the chance to review numerous documents related to Ameren, Missouri's environmental compliance planning process. Is that correct?
That's correct.
What are those numerous documents?
I have a binder here that I think if you look at the schedules to Mr. Whitworth's direct testimony, there's hundreds of pages of documents that were provided to Ameren that ESD reviewed to understand exactly what was going on with the NSR regulations, what was going on with all these cases. There are scorecards showing that by and large in the EPA NSR enforcement cases, the agency was losing more than it was winning. So if you look at those schedules, there's hundreds of pages worth.
So you're referring to the schedules that are attached to Mr. Whitworth's testimony? Is that what you're saying?
Yes.
Who was the president affect EPA's enforcement activities?
I'm sorry, ask again?
Let me limit it in time because I did not do that. In the 2000 to 2015 timeframe, does who's the president affect EPA's enforcement activities? And let me limit it to new source review enforcement.
Yes, yeah. That initiative went on during all administrations, but there was a time in 2006 maybe, or 2005, shortly after I left, where EPA announced that it would not bring enforcement cases unless someone had an emissions increase based on the potential to potential test that I talked about. So there was a time when the answer is yes, it has varied a little bit from administration to administration.
Was that change that you're talking about in 2005 at or about the time the EPA put out its proposed rule to change to the potential to potential test for new source review?
Yes, yes.
Did EPA's enforcement activities vary depending on who was president?
So I think I've answered that. So at least from that time period during the George W. Bush administration, they only brought new cases where there was an increase based on the potential test. So that was unique, I think, to that administration.
When did George G.W. Bush become president?
I'm sorry, George W. Bush became president in 2001, and he remained president until President Obama took office in 2009.
Did EPA's enforcement activities for new source review change earlier than the 2005 timeframe you indicated?
I don't think so. I mean, certainly when I was at EPA, there continued to be NSR enforcement cases.
Were there new ones?
I'm sure there were at least a couple of new ones. I only remember one in particular, but I was not really involved in the enforcement activities. I was just generally kind of aware of what was going on.
Are you familiar with applicability determines as, well, let's limit it to the EPA?
Yes, I am. Applicability determinations is quite a mouthful.
Okay, what is the impact of an applicability determination?
It's the formal way by which a company can seek a kind of a ruling from the agency on whether a certain regulation applies to a certain project. So that is something that is occasionally done. Yes, it's an applicability. It's similar to what the state of Missouri calls no action or no permit required letters.
Are you familiar with private letter rulings in the income tax field?
Only, well, I'm aware they exist. I'm not sure I fully understand kind of their legal import, but I've heard of them before.
Okay. What is the effect on the EPA of an applicability determination? For example, if it says you don't have to get a new source review permit or apply for one, is that binding on the EPA?
You know, as a practical matter, it is. I mean, I don't know legally if EPA later changed its mind, if they would be prevented from doing that. But I'm sure that there's never been like an enforcement action, you know, based on a different interpretation. So if your point is it binding as a practical matter? Yes, it would be.
Well, let's go to the, I'll pick one. 2005 Ameren, Missouri project at Rush Island Unit 1. Would it have been prudent for Ameren, Missouri to seek an applicability determination from the EPA for that project before it began that project?
No, it would not have been reasonable, and I'm not aware of any utility that has ever sought an applicability determination where it believed that its understanding of the law was so clear. The other thing I would say about that is because Missouri has an EPA approved program, it's actually MDNR that can do applicability determinations. So because it's a SIP approved state, you would not go to EPA, you would go to MDNR. But again, you know, companies do projects, even major projects, fairly frequently, and what they do is they look at their understanding of the law and the regulations and the conversations they've had with regulators and with others in the industry, and they make a decision. So it's highly unusual for someone to actually go to seek an applicability determination.
Well, you answered it wouldn't be reasonable. I asked whether it would be prudent. I think there's a difference. Do you?
I'm not sure. I mean, the other thing I can say is to get such a determination can sometimes take a couple of years. And I mean, I know that for a fact and so, you know, people don't have time to do those. So you know, if there are projects that needed doing, seeking an applicability determination. And I don't know how long, I suspect that MDNR moves more quickly than that. But EPA sometimes because sometimes they're controversial within the agency.
Well, didn't Ameren, Missouri know that it was having pluggage issues at Rush Island Unit 1 long before 2005?
Based on my recollection of the testimony of Mr. Whitworth, I think that's, I honestly don't know, but I believe that's correct.
Well, you understand that Rush Island was originally designed in the 1970s to, I'll say, let's limit it to Unit 1, to burn high sulfur coal, correct?
Correct.
And then in the 1990s, Ameren, Missouri started burning Powder River Basin coal because it had a lower sulfur content in order to meet emissions requirements. Is that not correct?
Yes, I know many utilities did that. So that doesn't surprise me that that's why they did it.
And didn't they have a lot more pluggage issues and maybe start having pluggage issues in the 1990s after started using Powder River Basin coal at Unit 1?
So I honestly, I'm not disputing that. I just don't know.
That's fine. I don't want you to say you know something you don't know. Didn't Ameren, Missouri put itself at risk without knowing for sure? Well, let's put it this way. Doesn't a prudent utility want to know what its risks are?
Sure. I'm sure that's the case.
Would not an applicability determination for the planned outages at, let's limit it to Unit 1, for the planned outage at Unit 1 in 2005, wouldn't it have reduced Ameren, Missouri's uncertainty about its risk if it had sought an applicability determination as to that outage and had sought it from the EPA?
So as I said before, I know I say this in my rebuttal. I don't think Ameren, Missouri thought there was a meaningful risk. And I'm happy to tell you more about what that was. So if your point, if they thought the risk was exceedingly low, would it have been even lower had they gone to MDNR? And as I said before, they wouldn't go to EPA. They would go to MDNR because MDNR, they have an EPA approved program, which means that MDNR is the permitting authority. They're the ones who implement the NSR program. So yeah, they could have further reduced an extremely small risk by going to MDNR, but they already knew what MDR would say because there's, we as we have in the record, there's a number of permitting decisions made by MDNR that say, if you undertake a project that doesn't increase potential emissions, you don't need a permit at all. So if they gone to MDNR, we know exactly what MDR would have said.
Okay, I'm
No,
going
you're
to
not
ask
answering the question. The question's about EPA.
Mr. Williams,
applicability.
hold on a second. It gets muddy for the court reporter and it gets muddy for me when the attorney and the witness talk over each other. So we're going to take a couple steps back and Mr. Homestead, if you would finish answering your question, and then Mr. Williams, you can go ahead and.
No, I think I'm finished. I'm sorry if I've gone on too long.
Go ahead, Mr. Williams.
Judge, would you please direct Mr. Homestead to answer the question asked, which was about seeking an EP applicability determination, not one from the Missouri Department of Natural Resources?
Ask the question again.
Could I have the court reporter repeat the question?
Hold on just a second. Let me see if I can find it back there. Okay. Was not an applicability determination. Sorry, that's my dog. I'm sorry. Let me start over. Was not an applicability determination for the planned outages. Let's limit it to Unit 1 for the planned outage at Unit 1 in 2005. Wouldn't it have reduced Ameren, Missouri's uncertainty about its risk if it had sought an applicability determination as to that outage and had sought it from EPA?
So my answer is there is no example anywhere of any utility going and seeking an applicability determination for a project like this from EPA when the state permitting authority was the authorized NSR permitting authority. So you're asking me if they did something that no other utility has ever done, would that further reduce their risk? I guess the answer is yes, but I'm not even sure EPA would give an applicability determination. They would say, you need to go talk to your permitting authority.
Are you aware in the Ameren 3 liability opinion, there's a reference to, hold on a moment. A memorandum from Don Clay, acting EPA Assistant Administrator, dated September 9th of 1988. At, the reference is to 3-4, and it's a DTE applicability determination detailed analysis. You familiar?
I am familiar with the DTE applicability determination, yes.
Now, there was one done in May of 2000 that was requested by Detroit Edison Company of EPA, is there not?
Yeah, that was not for a component replacement project. It was nothing like this one. And I think, I'm not even sure the state had an approved program. That involved something called a dense pack that was a more efficient turbine. And there was a question about whether, they weren't just making a like-kind replacement. They were not replacing a component with a functionally equivalent component. They were replacing a component with a newly designed component called a dense pack that would increase the efficiency of a plant. And because it was changing the sort of physical design capacity, that was a highly unusual situation. Again, I don't know if they went to EPA because the state didn't have a delegated program. I'm not sure, but it was a highly unusual. And as you may remember, I think that applicability determination took a couple of years. And when EPA came back, it still didn't solve the question. It said, well, this isn't a routine replacement because you're not replacing something with a functionally equivalent component. You're replacing with a new and improved version that actually changes the output of the plant. So it was very different from this. And as I say, it took, we could look and see, but I think it was close to a couple of years. And they still didn't resolve the NSR question. They only resolved the RMR&R question.
Well, let me read from portions of it and see if this refreshes your recollection at all.
Okay, yeah.
It's dated May 23rd of 2000, and it says, I'm responding to your request on behalf of the Detroit Edison Company for an applicability determination regarding the proposed replacement and reconfiguration of the high-pressure section of 2 steam turbines at the company's Monroe Power Plant, referred to as the Dense Pack Project. Specifically, you requested that the United States Environmental Protection Agency, EPA, determine whether the Dense Pack Project at the Monroe Power Plant would be considered a major modification that would subject the project to pollution control requirements under the Prevention of Significant Deterioration, PSD, program. We have reviewed your original request dated June 8th of 1999 and the supplemental information you submitted on December 10th, 1999 and March 16th of 2000. We provisionally conclude that the dense pack project would not be a major modification. I skip a line. Although the dense pack project would constitute a non-routine physical change to the facility that might well result in a significant increase in air pollution, Detroit Edison asserts that emissions will not in fact increase due to the construction activity, and EPA has no information to dispute that assertion. Does that all sound correct?
I'm going to object to this question, Judge. I had a hard time following it just listening, and the document hasn't been made available to Mr. Homestead. I don't think it's fair to just read a large portion of a document that he doesn't have and ask him if it's a correct statement.
I can email the document to the parties and the commission if that would help.
Can I just ask, who was the letter sent to?
Henry Nickel, counsel for the Detroit Edison Company, Hunton and Williams.
Okay, so.
Can't hear you.
No. So I would like to, I would actually like to read it. I guess my recollection was mostly correct. It involved the dense pack, and EPA found that it was not a routine replacement. And EPA said it had no information stating that it would cause an emissions increase and would therefore not be a major modification. So I mean, that's my recollection from
Here, I guess here's my question. We're getting into this. There's been an objection that's made, and now I've got a witness that appears to be answering the question. I've got the attorney who objected does not seem to be stopping his witness from answering the question. So my question at this point is, Mr. Homestead, are you answering Mr. Williams' question, or what are you doing here?
I guess I'm not answering since there's been an objection.
Okay. Mr. Long, if you were to receive a copy of that and have a few moments to peruse it, would that resolve your issues?
Absolutely.
Okay, why don't we do that?
That'll be fine. Do you want me to send a copy to you as well, Judge? Oops.
Yes. And I am bearing in mind, this is not an exhibit at this point.
I would like to have a copy of it too, just to look at it also. I can delete it. If he could send it to me or send it to Kayla Cleathermas and see if she could send it.
And Miss, why do you need to see a copy of this?
Just to read along.
Judge, I'll send it to you and let you distribute it as you see fit. Other than I'll try to get it to all the parties.
All right, if you'll send it to me.
Or maybe it's quicker if I just send it to you.
I'm sorry, say that again?
It might be quicker if I just send it to you and let you distribute it. However you want to do it.
Why don't you go ahead and send it to the parties and then send me a copy, and I will deal with the court reporter portion.
Okay.
And I know we're approaching the noon hour, Mr. Williams. Do you know how many, and don't take this in any way as me trying to rush you. I'm just trying to gauge whether to take lunch at noon or noon 30. So do you know how you are with questioning at this point?
I think I'm almost finished.
Okay, then I may hold break for lunch and maybe see, depending on the number of questions that are beyond Mr. Williams, where we are.
I don't know if this is appropriate, but could I ask, maybe if I could, well, if I could see the document and have a chance to read it over lunch, and if Mr. Williams has other, I don't know if that's appropriate or not, but that would keep us all from sitting here while I'm trying to read the document that I haven't received yet. If he has other questions.
Yeah, I don't know. I don't know at this point whether Mr. Williams has questions that build upon answers to that document or not. So at this point, why don't we just email the document and take a quick look at it rather than recessing?
I've sent it out. I don't know if you received it yet.
I have not, but sometime. Let me update.
Apologies, we're using the same computer for email as we are for the hearing.
You're not the only one. I got a reply from Nash saying he's unavailable.
And I still have not received a, let's go off the record rather than muddy it up with this for a moment.
Okay, I've looked through the document. It appears to be complete. No objection to it. I'm passing it to Mr. Homestead.
Just to clarify, you said you have no objection at this point?
That's correct.
Okay, let's go back on the record.
I'm sorry, I have to call the document up, Mr. Homestead, again.
And
Judge,
because I said
my
it off the record, I'm going to
Mr.
ask
Homestead
again.
has not reviewed it.
Mr. Long, you've had an opportunity to review the document, correct?
I have, yes, it's about a 30-page PDF. I've scanned through it. It appears to be complete, and I have no objection to the questioning on the document.
Thank you, Mr. Long. Go on with your question, Mr. Williams.
Mr. Homestead, have you had an opportunity to review, the first 6 pages of the document?
No, I haven't. I got it.
I kind of rushed this one. Let's give Mr. Homestead another couple minutes. I'm sorry, Mr. Long had an opportunity to review, but Mr. Homestead is not.
Okay, having read this type of documents before, I went to the conclusion at the end, and so I certainly understand what EPA's ultimate conclusion was. So if I need to look at other parts, or if you want me to look at the first 6 pages, I'm happy to look at that too.
Please do.
All right. Sorry. I'm sorry, I'm not very good at navigating with this.
And for my reference, Mr. Williams, the part you were reading earlier to question him about, what page is that on?
I believe it was all on page 1.
All right, I've skimmed all that.
Did I accurately, I guess, quote or? you
So I
got
don't
it all?
remember exactly what you quoted, but
That's what I
this is basically consistent with, I think, what I explained.
Well, this is an instance where the utility sought an EPA determination as to whether or not it was subject to, let's see, PSD permit requirements, correct?
Correct.
And the EPA said it was not, although it concluded that the project was not routine, correct?
So again, this was not anything like the component replacements that I was talking about. You asked me about the 100 or so projects that were listed on that schedule. And those were all projects where you're replacing a component with a functionally equivalent component. This letter is about something different from that. It fundamentally changes the design of the facility. So you know, I still stand by my assertion that I'm not aware of any utility that's asked for an applicability determination for replacing a component with a like-kind component. They didn't conclude that this would not trigger major NSR. They said that it wasn't non-routine, and as long as the company took actions to make sure that its post-change emissions were not any higher than its applicable baseline, then it could avoid triggering NSR. But this is not like this is not a determination that the project doesn't trigger NSR. It says you can avoid NSR, even though it's non-routine, you can avoid NSR if you maintain your emissions level below, below what they call the baseline.
Well,
so I think I was remembering it pretty well.
I agree, especially coming in cold. My point, though, is that the utility sought EPA determination before it engaged in the project to find out what the EPA thought. You understand that?
So yes, but it's not the same kind of project that, as I say, this is the one example I can think of where a utility actually sought an applicability determination. I don't know why they went to EPA instead of the state. It could be that the state doesn't have an approved program. I don't know that, but this is not a like-kind replacement. The dense pack was an upgrade, and I think that's why they went to EPA. But you are correct. Here's the one example I know of where a utility sought an applicability determination from EPA. And EPA said, here's what you need to do if you want to avoid NSR.
I'll go ahead and offer the document as an exhibit in the case.
Do you already have exhibits numbered, Mr. Williams? Where would this
I
fit
do
in?
not.
Would this be your exhibit 1?
That would be 100 or 200, I believe.
Okay.
You have you gave out numbers. I think we start with 200, staff's 100s, and companies 1 to 99.
Okay, are there any objections to admitting, and what do you want to call this with, Mr. Williams? 200, I guess.
Yeah, it'll be exhibit 200. It's a letter, EPA letter to Detroit Edison.
Thank you.
I think that might be
Objections? I apologize. Any objections to admitting the Public Counsel Exhibit 200, the EPA letter to Detroit Edison, onto the hearing record?
No objection from Ameren, Missouri.
I hear no further objections. Exhibit 200 will be admitted onto the hearing record. Go on, Mr. Williams.
Thank you. Mr. Homestead, do you know where the Monroe power plant that's referenced in this Exhibit 200 is located?
But where the plant is located, I believe
Yes.
it's probably, if it's DTE, it's probably Michigan, but I'm not completely sure of that.
Could it be some other state than Michigan?
I don't know where DTE has other plants. So so the answer is I don't know.
Okay. I think I'm down to my last question. On page 19 of your SIR rebuttal testimony, you state with emphasis that Ameren, Missouri had no way of knowing that EPA disagreed with this interpretation. And when you say interpretation, you're referring to MDNR's longstanding interpretation of the Missouri State Implementation Plan, close quote, until EPA initiated the enforcement action?
Correct?
Is that correct?
Yes.
Didn't Ameren, Missouri have a way of finding out that EPA disagreed with MDNR's interpretation?
So I guess theoretically, but as you yourself said, the plain reading of the Missouri SIP is exactly what MDNR had been saying for years. And when you are aware of the regulations and how they've been interpreted for many years by the agency in charge of implementing them, the idea that you would then go to EPA and say, well, in the off chance that you read this in a way that nobody else does, can you just assure me that you won't do that? I don't think any reasonable, I don't think any reasonable person would do that.
Wasn't it EPA that was doing the enforcement actions?
Yeah, but that didn't happen. That didn't happen until long after the project was taken. The enforcement action was initiated like in 2016, and the company had to decide in 2005 to 2010 whether it needed permits.
Hadn't the EPA taken enforcement actions long before then?
Not based on the Missouri SIP, nothing like this. There was no, my point in that sentence is the regulations on their face are pretty clear. The MDNR interpretation of those regulations is longstanding, and the company was completely reasonable to rely on that. And the idea that they would somehow intuit that almost a decade later, EPA's enforcement office would disagree. Nobody would go to EPA based on that kind of likelihood. Anyway, maybe I'm going on too long, but you're suggesting that they should have done something that no reasonable company would have done under the circumstances, given what they knew at the time.
That's your opinion as to whether it would have been reasonable, correct?
That's correct. That is my opinion.
What about, would it have been prudent to go to the EPA? Because you're talking about the potential for hundreds of millions of dollars of emissions control equipment.
I'm sorry, wouldn't have been, I don't, so I'm not sure I understand the difference between reasonable and prudent.
Mr. Homestead, would you wait? I'm actually going to get to that issue.
Okay.
If you're going to ask him that question, Mr. Williams, how are, just so that I know, how are you defining prudent as opposed to reasonable? If you're making a distinction, I want to know what that distinction is.
Reasonably prudent, I would use a negligence standard. I mean, what would a utility who's facing
not reasonable and prudent, you're separating the two. What's the difference between reasonable and prudent?
I think for something to be prudent requires more action than reasonable may require. It's not to say that somebody would be so cautious in their actions to not do anything that they ought to do, but they should be minimizing their risk and maximizing their knowledge about the consequences of their choices.
Would it be fair to say that for you, the difference between reasonable and prudent is that prudent is more cautious?
I think that's fair.
Okay. Mr. Homestead, do you remember the question, or do you need Mr. Williams to ask it again?
No, I think I understand the question. It certainly wouldn't have been reasonable. I don't even think it would have been prudent. I mean, you have an outage coming up. You have, I mean, I think at the time there was no way to know that there was any reason whatsoever. I just don't see that goes beyond. I mean, it's kind of like saying, well, are you prudent if you never drive anywhere in a car? Because there's always a risk that you might get in an accident. I don't think that's what prudent means. And again, I come back to the fact that I have this list here of 100 projects and they didn't involve the exact same combination, but none of those companies sought an applicability determination before they did those. None of those companies applied for an NSR permit because they didn't think they needed to. So no, I'm not saying it would have been prudent for the company to do something that didn't make any sense. And all those other companies faced the stakes were the same for all those companies, right? I mean, if in fact you triggered NSR and you knew that, you know, if you were going to spend $15 million to maintain your plant, and you might trigger a requirement to install $500 million of pollution controls. I mean, they all made the very same decision. As I said, none of them seemed to think it was prudent, certainly not reasonable to seek an applicability determination.
Did any of those companies that are listed in Schedule SEW-D6, were any of them subject to the Missouri State Implementation Plan?
No. Well, I shouldn't say that. I think the answer is no. I'd have to go one at a time and see, but I think the answer is probably no. TVA doesn't have any AEP. I could look at this, but I think the answer is probably not.
Well, how would we know if Missouri's SIP would have applied from looking at that exhibit? I mean, can you tell the region? Really what I'm trying to get at is, do you need to go through and identify that none of them are in Missouri, or can somebody look at that and tell without the need for you to do it?
Somebody who's aware of, so what I have is a list of companies. I don't know if any of them, so I have a list of companies, and then below each company, it lists the names of the units. So, you know, Duke Energy has 12 units where it did component replacements. TVA has 9. AEP has 12.
Why don't we shorten
the units, but I don't know where the units are located.
We are going too far in a field into the weeds here. Is the answer, Mr. Homestead, is that looking at that list, you do not know whether any of those utilities are in Missouri or not? Is that correct? Does that answer your question, Mr. Williams?
Maybe. Do you know if any of those utilities on that list are in Missouri?
I'm not aware of any of those utilities that are in Missouri, no.
I think that's the end of my questioning at this point in time. Thank you.
Thank you, Mr. Williams. Are there any questions from the commission at this time? I hear none. I've got a few questions for you, and some of them may just dead end out, and that's fine. Mr. Homestead, are you involved at all in Ameren's litigation before the district court?
No, I'm not. No.
How familiar are you with Ameren's district court litigation?
I've read the opinions, and I Anyway, there's 300 and something pages of opinions. I can't say I've read everything that was written, but I guess I'm pretty familiar with the case, certainly.
Okay, and that's kind of what I wanted to establish. First, how long on average, and I understand it's going to be all different lengths of time, is seeking an NSR review going to take? I mean, is that a lengthy process?
It varies so much. There's no standard answer. As I said, the one I was familiar with, I know took a couple of years. That's the DTE one that we were just discussing. That's the only one I can think of that involves utility. It doesn't happen very often, at least at EPA, that you ask for an NSR applicability determination. I can't think of any that have been, someone has asked for, even for a non-utility, for many years.
Now that SCW D6 schedule attached to Whitworth's testimony that you had cited in your direct testimony, that is, if I were to ask you, I'd asked the attorney beforehand about actions, about utilities that had made similar plant alterations without seeking permit approval. Is that the list?
So this is one list. There's another report that I referenced in my direct testimony by a fellow named Golden, and he was actually mentioned in the findings that Mr. Williams had me read. And so that's a separate list. There may be some overlap, but I wouldn't say the list that's in this memo is comprehensive.
Now, you just talked about the 3 findings of fact I believe Mr. Williams went over. And in Mr. Whitworth's direct testimony, he says, ESD emphasized that replacement of economizers, superheaters, reheaters, and water walls needed to be reviewed by ESD because we were aware that such component replacements had been targeted by the EPA in its ongoing NSR enforcement initiative. How does that square with how you had portrayed Judge Sibley's finding of fact earlier, where you said, well, all these things hadn't been done together?
I'm sorry, you have to ask the question again.
I'm sorry. So it's rather lengthy, but basically what it says is that Ameren's, I guess their ESD is their internal review, is that they were aware that replacement of economizers, superheaters, reheaters, and waterfalls needed to be reviewed by them because they were aware that the EPA was targeting those replacements. How does that square with your portrayal of finding of fact 74, where you indicated, well, yeah, these things by themselves are routine, but they'd never been done together like that?
So what I hoped I said was that precise combination had, at least Ameren was unable to identify a case where those 4 or 5 things had all been done at the same time. Certainly different combinations of those things and other components had been done at the same time. So that's the distinction. You know, the judge says, well, you can't find another example where all these exact components have been replaced at the same time in a plant. So it was certainly known at the time that EPA had targeted some of these projects in its NSR enforcement initiative. But for the most part, the courts had found that they were routine. So there were courts who went the other way, but and I know this is in Mr. Moore's testimony, if you look at the decisions kind of leading up from, the beginning of the NSR enforcement initiative to 2010, more than half the courts who had looked at those types of projects had said they were routine.
Now, you had said earlier that the commission doesn't determine violations of the Clean Air Act. That's absolutely true. We don't do that. It appears that the district court has made that determination, and that's nothing that we're going to be doing in this case. We're certainly not relitigating that issue in any way, shape, or form. But that kind of leaves me, I'm not 100% sure, and maybe you can explain to me, why is the commission looking at this issue?
So my understanding is that at least OPC and maybe the staff believe that because Ameren lost in the enforcement case, that makes its decision not to get NSR permits automatically imprudent and unreasonable. So I believe that, and that's certainly the opinion of Mr. Majors. He's pretty clear about that, and so I think that's why we're looking at all at this district court case that came, many years after the fact. As I explained in my testimony, the judge in that case did not so under the Clean Air Act, it's a strict liability statute. It doesn't mean that you were negligent, even if you were, the decision that you made was prudent and reasonable. If a court found it was wrong, then you're liable.
Yeah, it's like speeding. You're either speeding or you're not speeding. We're not looking at why.
Right, and if your speedometer was broken and you had no way of knowing, that's a good example. You're speeding. That's even if you have a reasonable explanation for why you were speeding, it doesn't matter. I've talked about sort of the three different reasons why Ameren, Missouri concluded that it didn't need a permit. The judge went through those, and he ultimately concluded that in fact he says that the problem is they started with an incorrect understanding of the law, and based on the correct reading of the law, which was declared by him, they violated the Clean Air Act. But he never said that their understanding of the law was unreasonable. He didn't say that so the issues before the district court were very different from the issues that are now before this commission. This court doesn't even have jurisdiction to determine whether their decisions were reasonable. As I say, that's outside of his lane, outside of his jurisdiction. And so to my mind, I don't want to say the district court decision is irrelevant, because it establishes that there was a violation of the law, but nowhere does the district court say that on those specific issues that Ameren had its understanding of the law was unreasonable. In a couple of the places, the court criticizes the emission calculations they had done, but he's criticized, and he says those were not reasonable, but they were not reasonable given his understanding of the law. And Ameren believed, as most other utilities did, that you didn't need to do an actual calculation if you determined as a matter of engineering judgment that you weren't going to cause an emissions increase. So I don't want to say he never used the word reasonable, but he didn't use it in the same sense that I think the commission treats that. So that may be a long explanation, but I think that's why some people are pointing to the district court decision. But as I say, that's hindsight. That came many years after Ameren made its decisions that it didn't need to get permits.
Would it be a fair statement to say that that Ameren's position is that it was wrong about the law, as the district court has informed it, but that its decisions based upon its faulty interpretation of the law were reasonable. Is that Ameren's position?
So I think that's, yes, that's Ameren's position, and that's, I guess, my opinion as well. But I would take one further step and say their understanding of the law was entirely reasonable. And so it wasn't just that. So I think you would have to, if they had an unreasonable interpretation of the law, then you could say that they should have known differently. But I think their understanding of the law was reasonable, even though it turned out to be incorrect. And that's what the judge said. He didn't say that their interpretation was unreasonable, just that they had been wrong as a matter of law.
But the court in the 2019 decision did determine, well, in analyzing their 2017 decision, as I believe you alluded to at the very beginning, it did determine that the decision to not seek permitting was an unreasonable decision.
I don't think that's a fair reading of the case. And that you probably know this in your position, but not everything that a judge says or writes is legally relevant. And the word that lawyers use is a Latin word called dicta, and it's a pretty commonly understood term that even in a written opinion, if the judge says something that is not relevant to the underlying holding, that so he did use the word reasonable. He never used that. He never said they were unreasonable when he looked at their reasons for just concluding they didn't need a permit. If you look at the 2017 liability decision, he doesn't say that anywhere. In the remedy opinion, where he had already made that determination, he says, yes, they weren't reasonable in not getting PSD permits. But he doesn't explain that. That sentence is entirely dicta because it has no legal relevance to the holding. There was no way for, I don't know that Ameren thought that the use of that word in one place in 300 and something pages of opinions would come back to bite it. But even if it had no way of challenging that because it wasn't relevant to the holding. So what you can challenge to it, an appeals court is not dicta. What you can challenge is the court's holding. And the court's holding was that Ameren violated the law by not getting permits.
Well, I remember reading that section of your testimony, and I was kind of taken aback momentarily in reading that, because I will agree with you as to the 2017 opinion. And there's nothing flagged in there that says, we find this unreasonable or we find that. The findings language you would normally see in the findings of fact. But I think it's quite clear in the 2019 decision where it says, having previously concluded that it was unreasonable of Ameren to seek. I mean, when you say concluded, that doesn't strike me as dicta language.
But he's characterizing his earlier, to my reading of that, it's kind of a shorthand for saying I found that they violated the law. Having concluded that it was unreasonable for them not to get permits, then he goes on to the remedy. But as a lawyer, what I would say is, if you're going to make that kind of conclusion that has legal meaning, you need to explain it. And the only place that would have been relevant was in the liability opinion. You look through that 2017, and there's nowhere where he says that that it was unreasonable for Ameren to interpret the Missouri SIP the same way that MD&R did. It was unreasonable for them to interpret. I don't think any court would ever say that, and he certainly doesn't. He disagrees with their understanding of the RM&R exclusion, but he never says that it's unreasonable. The one place where he does say that they're unreasonable in the liability only has to do with these emission calculations. But But Ameren's view was it didn't need to do the calculations because it knew as a matter of engineering judgment that it wouldn't cause an increase in potential or actual emissions. After they started the project, they had someone do an emissions analysis that the judge found fault with, and he said it was unreasonable, and I don't disagree with that. But that wasn't the basis of Ameren's conclusion that it wouldn't cause an emissions increase. As I try to explain in my testimony, what he was so unhappy with was a calculation that Ameren had not actually relied upon in making its decision that no permit was necessary.
Thank you. I don't remember in any of your testimony, certainly I don't remember in your direct testimony, you don't address potential harm from Ameren's decisions, do you?
That's correct, I don't.
Okay. All right, those are all the questions I have for you, Mr. Homestead. Thank you. Is there any recross based upon my questions?
I have just a few, Your Honor.
Go right ahead, Ms. Mears.
Do you recall discussing with the judge how long the NSR process takes?
Yes, I do. Yep.
Were you aware that Ameren had delayed both of its outages?
I was not aware of that, no.
Okay. Would it be reasonable to assume that if Ameren was able to postpone the outages, that the projects were not critical for functioning?
So I don't know enough about the projects and the timing, but you're saying that they could have delayed them even more because they were not critical for functioning. I don't know that's. I don't disagree with that, but I just don't know.
So wouldn't you agree then that Ameren could have waited for the NSR process to complete based on that information?
I assume they could. I mean, I don't know what the downside with the cost would be. I'm sure there was a reason they did them when they did. But as I don't know. I know I repeat myself, but no reasonable utility would ever do that when the laws seem to be so clear. And to me, if you're looking at what's reasonable, what's prudent, unless you say everybody in the utility industry was unreasonable and imprudent, I don't know how you can say, well, everybody should just wait until they get an applicability determination. That's not required under the law. It's not required under MDNR. So that the suggestion that somehow that's what they should have done when no one else does that, when their understanding of the law was pretty clear, I would have actually found that to be quite unreasonable.
But would any harm have resulted to Ameren?
So you'll have to get someone else. That there's usually, my impression is when they're doing a big maintenance or repair project, they're doing it at a certain time for a reason. So if you say, well, if we put that off for a year, what harm would there be? I assume you would have plants that were less reliable and maybe less efficient. But I don't.
But they did postpone and put off the outages, in which.
Right, but so I don't know how long they did that. I don't know how that would have meshed up with the need to get an applicability determination. If that would have caused them to postpone them even more, I don't know.
Thank you. No further questions.
I once again was any further recross?
Not by public counsel.
Okay. I hear none. Any redirect from Ameren?
Your Honor, there will be redirect, but can I take up a matter just briefly off the record to talk about the schedule?
Does it affect answering my question?
Oh, yes, there will be redirect, but
I mean, does it, is that, is, let's go off the record. Okay, what is it you wanted to tell me?
We're back on.
Judge, it's still muted.
I don't know why I'm having difficulty with the mute button today, but I am. Are there any objections to taking a 1 hour lunch break? And we are back on the record. Is that correct, Ms. Richards? That's what I heard you say.
Yes, we are.
Judge,
hear no-
would it be possible to shorten the lunch break period?
Of course, Chair. What would you like me to shorten it to?
30 minutes to 45 minutes.
I am fine with that. I believe everybody can get everything they need done in that time. Why don't we take a 30-minute recess and we will take up again at 1:10.
Thank you.
And I will recess until 1:10. Thank you.
Thank you.
And we are
And
off the record.
then, can I say something?
Mr. Lowry is, Your Honor.
Thank you. Ameren, Missouri.
Yes, Zach Ashlong is here as well.
Thank you, Mr. Long.
The court reporter is back.
Thank you, Ms. Richards. Sorry, Richardson.
It's okay.
Okay, I can see Mr. Williams. Okay, why don't we go on the record, and I will take care of a couple of housekeeping matters. Ms. Richardson, are you ready to go back on the record?
Yes, sir.
Okay. All right, let's go in the back on the record. I'll take care of a few housekeeping things. I have been asking all morning whether Missouri Industrial Energy Consumers, MIEC's attorney, who I thought was going to be participating, was here. I received an email from MIEC's attorney indicating that they are out of the country, and while they have tried to attend, have been unable to log in. And that is maybe a difficulty of the geographic location that that attorney is at. However, this attorney says that that they did not have any testimony or position on this morning's issues and would have waived opening statement and cross had they been here. So for the record, that is what happened with MIEC's attorney. MECG's attorney has asked to be excused for the remainder of the hearing today, and I'm going to grant that request. So Mr. Opitz, on behalf of MECG, will not be back today. With that in mind, we left off. It was we were just about to begin the redirect from Ameren, Missouri, of witness Jeffrey Homestead, who we are taking out of order today. So with that in mind, Mr. Long, if you want to go ahead and redirect, you are welcome to do so.
Judge, I apologize. This is Jeff Keeble. Let me ask one question. Since this is the first witness of the hearing, just wanted to clarify. Redirect is limited to anything in particular, or any questions, or any party's questions, or
cross-examination. Cross-examination is generally unlimited. Redirect is usually limited to subjects that have already been covered.
Thank you.
All right, Mr. Homestead, are you ready?
Yes, I am.
Okay. I want to go back to a subject that has been covered. I think you discussed this subject with Judge Clark. And he asked you some questions about the 2017 opinion by the district court and the reference in that opinion to the finding that the judge made. Do you recall that?
Yes, I do.
And he was referring back into the, from the remedy opinion in 2019, he was referring back to the 2017 opinion, just to orient you.
Yes.
Okay. And I think it was in the 2019 remedy opinion, you had this discussion with Judge Clark. If I said 2017 liability, I apologize. In the 2019 remedy opinion, there was a reference to a conclusion that had been made in the 2017 opinion that the failure to obtain permits was not reasonable. Do you recall that discussion with Judge Clark?
Yes, I do.
Okay. And in the 2017 liability opinion, was there a conclusion that the company had an unreasonable understanding of the law?
No, nowhere.
Was there a conclusion in the 2017 liability opinion that the emission calculations offered by the company at trial were unreasonable under the law?
Yes.
And so how do you address the issue? I think Judge Clark raised this up. How do you reconcile the use of the word concluded in the 2019 remedy opinion with respect to unreasonableness, and your position that that was dicta in the 2019 opinion. How do you reconcile the two?
So as I tried to explain in my testimony, there were three reasons why the company concluded that it didn't need to obtain an NSR permit. One of those was they didn't expect that it would cause, I mean, we're talking about two different emissions increase tests. One is the potential, no increase in potential emissions, and that's the standard that people understood under the Missouri SIP. That's not what we're talking about here. Ameren also concluded, being aware of sort of the next step in the Missouri regulations, that simply for engineering reasons, their understanding of the plant and the fact that it had significant unused capacity, they concluded that the projects would not cause an increase in actual annual emissions. They made that conclusion without doing any calculations because that was their understanding of the Missouri SIP. I was interested to note that under the Illinois, remember ESD covers both Missouri and Illinois. In Illinois, they did do emission calculations because that's what they understood the SIP to require there. But in Missouri, their understanding was that was not required. So it was not as though they were against doing emission calculations, but they concluded that they didn't need to do those. At the trial, however, after they had received the NOV from EPA, and after they had already started the 2010 project, there was an employee there who was tasked with trying to do emissions calculations. And those calculations were never relied upon by Ameren. And as I said, they were made after the fact, and they were really kind of done for another purpose. But it was those calculations that the judge said was unreasonable. So when he was talking about, I know this seems very convoluted, but that was not the determination on which the company had decided that the project would not cause an increase in annual emissions. They provided no calculations because that was their understanding of the law. After they started, they had a fellow, I don't remember his name, who tried to do some emissions calculations that the judge found to be unreasonable.
So all of this was in the context of the remedy decision, referring back to the liability decision of 2017.
Right.
What was the issue that you understood it for the remedy decision to decide?
I think the remedy decision was only, at that point, the violations had been established. And the question is, well, what do you need to do to remedy those violations? And the remedy decision was all about what steps what steps Ameren would now need to take to provide a remedy for its violation of the Clean Air Act.
So in deciding that issue for the remedy decision in 2019, what relevance did it have to whether or not the permitting decisions were reasonable?
At that point, it was legally irrelevant. I mean, as I said before, I read that one sentence as being sort of a shorthand way of saying he found that they should have gotten permits. But the whole question of reasonableness, it was never an issue in the 2017 liability decision, and it really wasn't relevant to the remedy decision at all. Again, that was only about, well, what was he going to order them to do? And that's where he ordered them to install scrubbers for both Rush Island and the Labadee plant.
And did the judge make that remedy order immediately effective against Ameren, Missouri?
No, actually, he didn't. The company asked the judge to stay that order, arguing that that there was significant legal questions about some of his decisions, and that they would face irreparable harm if they were forced to go ahead immediately and begin making those investments. And the judge actually granted the stay, and he said he recognized that especially the issue involving the Missouri SIP was an issue in first impression, and that there was a chance that he could be overturned by the Eighth Circuit. So he certainly didn't think that the company's position on any of those questions was unreasonable. So make sure the timeline is unmistakably clear to everybody. After he makes a reference in the 2019 remedy opinion to the permitting decision as having been an unreasonable one, he then later stayed the implementation of that remedy decision. That's correct, yes. And what does that tell you about whether the company's permitting decisions were reasonable? The fact that the judge, even after having said all of this, stayed the implementation. Had he thought that they were unreasonable, I mean, it wouldn't have met the standard for a stay. There's a formula that the courts have to use in deciding whether there's a stay. And so if it was unreasonable, they would have had no likelihood of success on the merits, and they wouldn't have. So I guess the point is, if he really thought that their decisions were unreasonable as a legal matter, he couldn't have issued a stay of the opinion, because that would be sort of contrary to the judicial standards for granting stays. Thank you. That's all I have.
Thank you, Mr. Long. Thank you, Mr. Homestead, for clarifying that for me. We normally end with redirect. Oftentimes, if there's one or two questions that people are dying to ask, I will allow those. And since we have this witness for a limited time, I'm going to do that. Does anybody have one or two questions they want to ask? If not, I will excuse this witness.
Judge, I do have a question.
Yes, go ahead, Chair Hahn.
Hi, thank you for being here today. I really appreciate the testimony you've provided. But one of the things you recently said in your response drew a question. You said the courts use a formula, when determining whether or not to issue a stay. And I thought the word formula is an interesting one because it's not something associated with the court. Usually it's a test. Can you expand on that and tell me why or what is involved in that formula or test so that I can better understand what the requirements are for meeting that for a stay?
Yes. Well, thank you for correcting my nomenclature. It's probably better described as a test than a formula. So if a court is asked for a stay, it's very similar to the test for a preliminary injunction. The person who's seeking the stay has to show that they are raising a legal issue that is meritorious, that they have a likelihood of success on the merits. So they have to show that their appeal is meritorious, and that's what the courts say. You have to show you have a reasonable likelihood of success on the merits, and you have to show that if you don't get a stay, there will be irreparable harm. And then the courts also consider sort of the balancing of the harm, like what's the harm to the movement of granting if they don't get a stay, and what's the harm to the public interest if the stay is granted. And using that test, he had to have considered, in fact, he did say that they had raised, I think he said serious issues of first impression, and that they would that they would be forced to spend a lot of money before an appeal could be completed if he didn't grant the stay. So that's the test.
Thank you for the clarification. Much appreciated.
Any recross on the limited subject of that stay?
Judge, I don't have any recross, but I want to thank Mr. Homestead for his testimony here today. Appreciate it. I'm impressed by his memory.
Thank you.
Mr. Homestead does seem to have quite a good memory and a good grasp of his subject. All right. I believe, as indicated before at the beginning of this hearing, this is one witness we are taking out of order. This does not conclude this issue, which has further witnesses to be questioned. Some of the parties have indicated that they have reserved the right to offer additional mini opening based upon that. Mr. Homestead, again, thank you for your testimony today, and you are excused.
Thank you. Thank you for accommodating my schedule.
Thank you again. I have nothing further. I will look this weekend to see if I can find those district court opinions that I am interested in. And I will also do some research in regard to, hold on just a moment. I have it written down somewhere. In regards to getting the transcript that the district court asked to be filed with the commission in, and I will deal with that with preliminary matters on Monday and also field any objections to that request by staff. With that in mind, I'm going to adjourn this proceeding today, and I will see you all on Monday. Have a good weekend. And we are off.
Thank you, Judge.